Okay, been a little while. Let's see if this works, / anyone can hear me. Okay, been a little while. Okay, looks like it did. I don't know if anybody's here. 2 people here, that's exciting. I might be one of those 2, but we'll see. Hey everybody. I'm glad I'm not alone. It always feels a little awkward just talking to myself, even if I'm recording a video. So, anybody watch the Afro Man trial today? That was something. No Afro Man here yet, but yeah, we talked about that. Yeah, I think 90% of that case is not going anywhere at all. But the PDF file, which I hate saying because it sounds silly, the stuff against Newland, that might be a problem. But I think all the money stuff is out the window already. All the claims relating to the money. Is Hannah Payne the one who shot a guy in traffic? That is. It has been silly, and it has been. What do you guys think about the suit? Is he overdoing it with the suit? The super suit? I'm a fan, personally. I was thinking about what other historical defendants in high-profile cases would be able to pull off such a suit, and it's a small list. It's definitely a very small list. Not myself. Yeah, he's not backing down at all from the suit in the videos. I have had the, what is it called? The Battle Ram Hymn of the Republic, or whatever it is, stuck in my head for the past 2 days. But, okay. Doug doesn't think so. I love Doug. I'm really excited to see Doug's take on it on Thursday with Justice Served, I believe, is who is doing that one. I've had it for 3 days. Yeah, exactly. Okay. It does stay on theme, for sure. Did you guys ever see that clip of him crip walking while doing a guitar solo? I just discovered this myself. Let's see if I can pull it up. Hey, cat. This is the last thing we'll do, then we'll get into Hannah Payne. Where are we? Here we go. All right, now I just gotta hide some stuff. Then I gotta figure out how to switch this over. Oh man, I have too much stuff on both of my screens. Not Mike. Here we go. Here we go. There we go. There we go. Now we're cooking. Now we're cooking with gas. Anybody who can hit the C-Walk while mid-guitar solo is just fine by me. It's hard to hate on a guy like that. I didn't watch Hannah's trial. I'm curious about his differences to Spivey. I don't know Spivey. I don't even really know Hannah's case for that matter. But I saw that. Am I going to get another strike? Yeah, probably. I'm still salty about that time. I got those strike. I got strikes from, well, not strikes, but I got claims from, who was it? It was the labels, but it was the labels for like YFN Lucci, although he took his down. Who else? It was the guy from Memphis, Yo Gotti, Future, and Lil Boosie, because I like made a video about how their lyrics were being misused by Detective Tyrone Dennis, disgraced Detective Tyrone Dennis, in their prosecution of the Darren Mills case in Atlanta. Obviously, I'm not holding against them because they had no idea that the claims went out. But I can still be salty about it because that's my right, and I exercise my rights. Okay. So here we go. This is the case of Hannah Payne versus the state of Georgia. She lost at trial. That's why her name's first. Obviously, Georgia versus Payne at the trial court level. It is. I blame Future specifically because Future is obviously a big viewer of my videos. Oh, man. I'm so glad that case is going to a... Oh, wait, there's one more thing I want to say. I've told Kat about this, but there's a case I've mentioned on here a few times. The Devin Grant case. He's the one from Glynn County, Georgia, Brunswick, Georgia. He was convicted of murder in 15 years ago. He's like roughly my age. He was 18 or 19 when the crime happened. Anyway, somebody else confessed to the crime to their girlfriend. And the girlfriend went to the police and did a videotaped interview in which she told the police that her boyfriend had confessed to the murder, and that videotape was not turned over to the defense prior to trial, or ever, actually. And eventually Grant, the defendant, my guy, he found out about the video because he was helping somebody else with their discovery, and it was in that other person's discovery, which is an incredible stroke of luck. And it was raised in the motion for new trial and to the Georgia Supreme Court, and they said it was not a Brady violation because it would not have likely changed the result of the trial, which is insane. But the reason why, I'm actually not going to get into the reason why, but we have we have some good reasons to why that was incorrect, and there's some other stuff that's come up since then. But anyway, I found a lawyer in Georgia who's going to work on the case with me, and it's somebody that you'll all recognize, and I'm really excited about that. So hopefully we'll be announcing that soon. But somebody that I'm sure you're all a very big fan of, and if you're not, shame on you. But yeah, that other lawyer's already agreed to take the case with me, so that's my next project. So hopefully I'll be able to talk about that soon. I think this case is the most egregious example of misconduct on every level that I've ever seen. I don't even think it's particularly close. Just failures by everybody involved at every level. The trial judge was removed from the bench. The trial prosecutor is currently under investigation for corruption. Defense lawyer, he probably should have tried, being a defense lawyer. All the appellate attorneys failed. The original habeas judge forgot about the case for 7 years and never ruled, and just left my guy to rot in prison without ruling on the habeas. So, a lot happening in that case, but yeah, hopefully we'll have some news soon and get into more detail. Jackie Johnson is prominently featured in the case. She lied through her teeth to the Georgia Supreme Court. She completely fabricated the timeline of the case. Even in the light most favorable to the state, it was still dishonest. Not to besmirch the good name of Jackie Johnson. But, okay. So here we go. Hannah Payne. All I know about this case is what I have read in this document. So, let's get into it. Oh yeah, this is being argued tomorrow at 7 a.m. Eastern, or no, 7 a.m. my time, 10 a.m. Eastern, and I'll be going live for that. Oh, and my guy in that case, he's really, really, really smart. He's a really good guy. And I don't say that lightly. He's very bright. No criminal, no gang connections whatsoever. Confirmed in the by the lead investigator. No gang ties. He did get caught smoking weed when he was like 16. So if you want to call that a prior offense, have at it. But no criminal record otherwise. Still no criminal record whatsoever. The guy who confessed also pled guilty to shooting somebody, and he went to trial on shooting somebody, a third person. And he actually got scooped up by the FBI on a major drug trafficking ring like last month. Firearm charges, gang charges, murder charges, lots of stuff. But okay, Hannah Payne. Going to focus on this one now. As you will see, this is the wrong one. Hannah Payne, represented by these two new lawyers trying to make a name for themselves. I really hope that Andrew Fleischman and Brian Steele, whoever they are, can really build a career for themselves, because they're not getting it. Sorry. I'm kidding. Obviously, these are two of the best of, certainly appellate attorneys in the state of, I'd say they're the two best appellate attorneys in the state of Georgia. I actually have Andrew number one, personally. But, you'll do okay with Brian Steele. But yeah, I think they're the two best. This brief, I believe, is written by Andrew. It's much more Andrew's style than Brian's style, although I'm sure they both worked on it. But I think we'll read through this one in full and then skim the state's response. Just because I want to get to the other stuff that, the stuff with Kat, the oral arguments that I was requested to watch. Read to us. I will. Okay. This case was decided on the wrong legal theory. That is in a, see, Brian, the reason I think it's their cup, one is very much Andrew's style. Brian doesn't write like this, but Brian is very tied to the numbered paragraphs. He loves numbered paragraphs more than anybody. Andrew's also my number one. Yeah, it's a great opening. This is great legal writing. Okay, I'm not going to break down every sentence like this, but here we go. This case was decided on the wrong legal theory. The jury was instructed that Hannah Payne's attempt to stop an impaired hit-and-run driver was unlawful unless she was acting in self-defense. That error dictated the verdict. The jury was never instructed that they could acquit if Ms. Payne was acting to defend others or to arrest the driver. So basically, the jury was instructed on self-defense as opposed to defense of others, or in addition to defense of others. Ms. Payne saw Kenneth Herring strike a semi-trailer, ignore police commands, and flee the scene in a smoking, disabled truck. Following police directions to get his tag number, she pulled over in front of his truck and approached. She told him to get out. Instead, he grabbed her by the neck, dragged her halfway into his truck, and accelerated. Ms. Payne told Mr. Herring she had a gun, grabbed it from its holster, and pointed it at him, yelling, "Stop." When he tried to twist it from her grip, it fired, mortally wounding him. Ooh, I'm sorry. Andrea Burkhart just liked my tweet. And so I got distracted there because I was overcome with fanboy emotions. That's my bad. Okay. The state cast Ms. Payne as a would-be police officer who should have just gone home rather than tried to help. But prosecutors never denied that Ms. Payne's goal was to keep her community safe from an impaired driver. Failing to tell the jury that this goal was every bit as justifiable as self-defense rendered her trial fundamentally unfair. We ask that Ms. Payne be granted a new trial with an adequately instructed jury. It's funny, you see this online a lot. There'll be a self-defense case, a really defense of others case. And some moron will be in the comments like, it's defense of self, not defense of others, when really it's both. I agree, Aaron. Okay. Aaron's are running the chat right now. This court has jurisdiction because it's an appeal from a conviction for murder. True. Wasn't he having a diabetic emergency? I don't know, but definitely possible. I know that I actually just read the brief where I got the information from. Hannah Payne was convicted on December 12th, 2023. Motion for new trial on December 22nd, within 30 days. If you watched my last video, you'll understand that significance. Denied December 12th, motion of appeal followed on the 26th. This is an Aaron Gang stronghold. Trial counsel erred by failing to seek an instruction on citizen's arrest, failing to seek an instruction on defense of others. On May 7th, 2019, this one goes back a ways, off-duty officer Terry Robinson witnessed a Dodge truck blow through a red light and slam. This is great. This is also good legal writing. Blow through a red light and slam into a semi-trailer. He asked the at-fault driver, Kenneth Herring, if he was okay, but the man seemed impaired. Herring asked confused questions, refused commands to get back in the truck, and began wandering around. Mr. Herring's eyes were glassy, and he seemed out of it, though Officer Robinson testified he did not smell alcohol. Mr. Herring's behavior was so off that Officer Robinson requested an ambulance. Mr. Herring was not safe to drive. Who was it? The Aaron, I think, that said, yeah, wasn't he having a diabetic emergency? That does track with what was said there. Also, Kat did that stream about memory, and actually I have her page up right now. The Penn and Teller Tickets to SCOTUS Investigative Hypnosis. Memory is really fragile. There was a study done, I think it was by somebody at USC, actually. At least I heard about it at USC. And one of the professor talks. If you show somebody a video of a car collision, and then you ask them how fast they estimate the car to have been going, what if it was UCLA? That's not valid. If you ask them, for example, how fast was the car going when it collided with the semi-trailer versus how fast it was going when it slammed into the semi-trailer, you'll get dramatically different answers. Even just the phrasing of a question in a suggestive way, just with, active verbs like that can yield completely different results. It's really interesting. How fast was the car going when it collided? How far above the speed limit was the car when it collided? Things like that. After about 20 minutes, while Robinson was speaking to the other driver, Mr. Herring declared that he was ready to go. Officer Robinson told Mr. Herring that he couldn't go. There was an accident and he seemed impaired. Herring ignored the officer, jumped into his truck, and flirted it. Matt and I are also a gang of sorts. Slat, cat, Matt, chat. Officer Robinson reflected that given all the signs that Mr. Herring was not in his right mind, he should have took the keys. Also at the scene of the accident was Hannah Payne, another concerned citizen who had stopped to assist after Mr. Herring's collision. Ms. Payne stood quietly off to the side in case she was needed, making no effort to talk to Herring or the officer. When Herring accelerated into heavy traffic, more good writing, Officer Robinson called out to her to jump in her black Jeep and get his tag. I really can't stop reading chat. As Ms. Payne followed Mr. Herring, she spoke with the 911 dispatcher, relaying where Herring was going and what he was doing. The dispatcher told Payne to be safe. Ms. Payne testified that her goal was simply to follow Herring until a police officer could arrive and detain him. Eventually, Herring stopped in a turn lane, either because he had decided to stop running or because his truck was visibly smoking and dripping liquid, as Ms. Payne pulled out in front of it. Take a shot every time we distract him. Would I be responsible for your deaths, like legally, if I get distracted too many times and somebody dies of alcohol poisoning? I don't know if there's a duty there. Is there a duty between a YouTuber and his viewers sufficient for imposition of negligence liability? I hope not. At this point, there were multiple eyewitnesses, including Ms. Payne herself, Miss Jackson, Mr. Cameron Williams, Ms. Tiana McCraney, and Ms. Shakanda Rosser. Each account of the incident is distinct. It usually is. Hannah Payne testified that she approached Mr. Herring's vehicle still on the phone with 911, explaining that police were on the way, that he needed to get back to the original accident site. When she got closer to the truck, Herring slapped the phone out of her hand and grabbed her wrist. He said, "I have something for you, friend," grabbed her by the neck and kept pulling. Ms. Payne said that she was trying her best to get away, but he was too strong. He ripped her shirt. Ms. Payne also suffered a black eye and a lacerated upper lip from the struggle. Ms. Payne believed that Mr. Herring was reaching towards something as he pulled her. He pressed down hard on the accelerator with the engine revving and hissing. This is great writing. Revving and hissing. Ms. Payne drew her sidearm. Mr. Herring grabbed the gun, trying to pry it out of Ms. Payne's hands. Again and again, Ms. Payne told him to stop. The gun fired. Suddenly, Ms. Payne was free, stumbled back from the car, and grabbed her phone off the ground. She spoke to the dispatcher, saying she needed an ambulance. She reholstered her sidearm and waved to get an approaching officer's attention. Ms. Jackson testified that she saw Ms. Payne maneuver her car in front of Mr. Herring's truck after weaving through traffic. Ms. Payne started fighting him through the window. Then she pulled a gun, immediately shot him, and said, "Now you need an ambulance." That's pretty bad. Bad facts for the appellant, but not dispositive. Ms. Jackson was adamant that Mr. Herring did not try to grab the gun, and that Ms. Payne's demeanor was thugged out and without remorse. Not great. On cross-examination, Ms. Jackson admitted that during the incident, she was actually positioned one or two cars behind the red truck and had to pull around to see what was happening. She also admitted that she had not actually seen Ms. Payne maneuver her Jeep in front of Mr. Herring's truck and had only come across the scene while Ms. Payne was already struggling with Mr. Herring. According to Rosser, Ms. Payne cut Mr. Herring off from his lane of travel. The truck tried to push through her Jeep but couldn't. Ms. Payne approached Mr. Herring's truck, screaming, and began striking him repeatedly in the chest while he took no steps to defend himself. Ms. Rosser said she could tell there was something wrong with Mr. Herring. Ms. Payne told Mr. Herring to get out, pulled her weapon, told him to exit the truck again, and he completely failed to react. She began punching him again. Then Ms. Payne reached her arm inside the truck to unlock the door and get him out, which took 1 to 2 minutes. According to Ms. Rosser, Payne then stepped back, drew her gun with her left hand, and began punching again. Thugged out is crazy, it really is. Ms. Rosser testified that another man, a bystander who police never located, approached Ms. Payne to stop her, that she brandished her firearm, and that he backed off and fled in his car. She was the only witness to testify to this. Ms. Rosser did not witness the gunshot and did not know where the gun was located when it went off. Let's see. Ms. Tiana McCraney testified she saw Ms. Payne and Mr. Herring struggling after Ms. Payne came to his window and told him to get out of the truck. She was somehow halfway inside his truck. As Ms. Payne was halfway in the window, Mr. Herring accelerated, striking her Jeep. Ms. McCraney did not witness the shooting, but she testified that Ms. Payne's demeanor afterwards was calm, handed her weapon to police. Mr. Williams, another bystander, saw Ms. Payne and Mr. Herring struggling with the gun. She was on her tippy toes as she was being dragged into the car. She was yelling, "Stop." Mr. Williams thought he saw Ms. Payne picking up a shell casing off the ground, although she testified it was her cell phone. Defense Exhibit 21 appears to show Payne picking up a phone. To explain Mr. Herring's demeanor, the state had Mr. Herring's sister, Vicki Herring, testify that he was insulin dependent. Although the autopsy showed that his blood sugar was normal, Dr. Stacy Deamores, of Love, I believe, testified that this does not prove Mr. Herring had normal blood sugar at the time of his death. Mr. Herring had no alcohol in his system at the time of his death, and the drug screen came back negative. Although he had needles and dozens of small baggies in his car, the state argued that these were all related to his diabetes. Makes sense. Law enforcement failed to take these baggies or needles into evidence or test their contents to see whether they could have explained Mr. Herring's erratic behavior. According to Dr. Deamores, there was stippling in Mr. Herring's wounds indicating a close-range gunshot. Makes sense. Shot in the abdomen. Genetic testing was performed on the gun, confirming 2 male contributors, and Mr. Herring was not excluded, implying that it's possible that he could have been grabbing the gun. Hey, Serial, I have to confess I voted guilty on law and crime poll. That's fine. I mean, the defense here isn't even that she didn't shoot him. It's just one of the affirmative defenses wasn't raised. So this brief almost takes the position that the verdict was correct. I mean, the appeal kind of takes the position that the verdict was correct given the instructions that the jury was given. So, makes sense. Ms. Payne was convicted of malice murder, felony murder predicated on ag assault and false imprisonment, and 3 counts of possession of a firearm during commission. Wait, that's not how that works. Oh, yes, it is. I forgot about that. It's each felony. Sorry, I'm just talking to myself right now. This doesn't matter at all. She was sentenced to life in prison, plus 8 years consecutive for false imprisonment, plus 5 years consecutive for the firearm counts. This is mandatory consecutive, so that's not discretionary. I know judges get confused sometimes on how firearm counts get sentenced. It's really confusing. Trial counsel... Sorry, if it seems like I was being disrespectful there. It's because I meant it that way. Trial counsel erred by failing to seek an instruction on citizen's arrest. Under Georgia law at the time of the shooting, a private citizen may arrest an offender if the offense is committed in his presence or within his immediate knowledge. The arrest may be for a felony or a misdemeanor, and it includes the right to pull someone over for offenses as minor as speeding. Trial counsel believed that this defense was unavailable here. This is going to be a quote from probably the motion for new trial hearing, where the defense lawyer is being questioned by probably Andrew or Brian. This sounds like Brian. Brian loves the "is that fair to say?" So you couldn't use the citizen's arrest statute because it had been repealed. Is that fair to say? Yes. However, the citizen's arrest repeal statute was not retroactive. This act shall not apply to rights and duties that matured, penalties that were incurred, or proceedings that were begun before the effective date of this act. Ms. Payne's right to rely on OCGA 17-4-60 matured in May 2019, years before the repeal took effect. Further, the ex post facto clause forbids the government from substantively altering criminal laws retroactively. Makes sense. Let's summarize this. Since arrest is so silly and abused, I'm already biased against this appeal. Yeah, that's fair. I mean, they repealed it for a reason, so you're not wrong. So basically, they're just saying that the trial defense thought that because citizen's arrest statute had been repealed, they couldn't use it at the trial, which was incorrect because while it had been the statute had been repealed, the crime in question happened before it had been repealed and was in effect at the time. So it's just a misunderstanding of substantive law. The defense was available because Mr. Herring committed multiple crimes in Ms. Payne's presence. It is a crime to drive a car while visibly intoxicated. It's a crime to flee the scene of an accident. It's a crime to endanger other drivers on the road by driving erratically in a disabled vehicle. No reasonable person would want Mr. Herring on the road, and even an off-duty officer, like Robinson, wanted to detain Mr. Herring until police could arrive. Trial counsel failed to request a citizen's arrest instruction in this case solely because he failed to conduct any research on a basic point of law. It's kind of savage. An attorney's ignorance of a point of law that is fundamental to his case, combined with his failure to perform basic research on that point, is a quintessential example of unreasonable performance under Strickland v. Washington. Trial counsel's failure to conduct this basic research was not strategic. Trial counsel even admitted that Ms. Payne could not possibly have been acting in self-defense when she stopped Mr. Herring's car. But it seems as though trial counsel did not consider whether Ms. Payne's later actions could be justified as if she was the initial aggressor. Trial counsel's decisions were the result of a series of legal misunderstandings, not strategy. That really gets to the core of Strickland. I don't know, Ariel. If you find it, link it in chat, though. I think everything. I think the trial is on YouTube. I don't know about the motion for new trial, though. But yeah, this is kind of the core of Strickland. the state always argues that every decision is strategic, even if it's clearly not. But a bad strategic decision is not an effective assistance, as long as there's some, some basis for the strategy, even if it's a bad idea. But again, this is why you have motion for new trial questioning, to establish that it wasn't strategic, but based on a bad decision. Oh, good lawyering there. Strickland, I hate you. Yeah, I do too. One of my pet peeves about Strickland, not really Strickland, but the way the state argues it, is they'll just say, like, oh, this decision was clearly strategic. Like, yeah, probably, but was it a good strategy? Like, was it a reasonable strategy? I mean, almost by definition, everything's strategic. They seem to miss that second part. The deficient performance prejudiced Ms. Payne in two ways. First, the evidence supporting citizen's arrest was strong and undisputed. Second, given only a self-defense instruction, the jury could not have acquitted her on these facts no matter who they believed. Okay, those of you who voted guilty, Brian Steele agrees with you. And Andrew Fleischman agrees with you. So if you voted guilty in the Law and Crime chat, you're basically Brian Steele. So there you go. The evidence that Ms. Payne was attempting to arrest Herring in this case was so strong that the state made it the first thing it addressed in its closing argument. Mockingly quoting Ms. Payne, the prosecutor said, "I mean, not that it has anything to do with it, but my entire life until I was 18 and my grandfather passed away, I was going to be a police officer." And on May 7th, 2019, Ms. Payne got her opportunity. Damn, that's really bad for the state. Oh, man. That's funny. It's really bad at trial, at the first trial, but now they're essentially acknowledging that she was acting to arrest somebody, as does a police officer, which kind of plays into the propriety of a citizen's arrest instruction. So, while it was kind of a clever thing to say for the state to say in the first trial, it's really biting them now. Officer Robinson told Ms. Payne to follow Mr. Herring to get his tag number and testified to his regret that he had not personally detained Mr. Herring by taking his keys. Ms. Payne called 911 as she followed. Ms. Payne told Mr. Herring to stop and get out of the truck until police arrived. The state presented no evidence that Ms. Payne knew Mr. Herring or had any sort of personal animus against him. She simply did not want him to kill somebody on the roadway. This had nothing to do with her. What? Because the jury was instructed only on self-defense, they could not acquit Ms. Payne unless every use of force, including blocking Mr. Herring in, was in self-defense, which was impossible. Ooh, look, Andrew's using M dashes, so it's probably AI. It's not AI. Again and again, the state told the jury that if the false imprisonment was not in self-defense, nothing that followed could be justified, even if Mr. Herring was trying to kill Ms. Payne to escape justice. So, yeah, I guess the point would be that it's not false imprisonment if you're making a citizen's arrest, which makes sense. So once she blocked his vehicle in and blocked his access, blocked his movement, the false imprisonment was complete. She had no legal authority to do this. She is not post-certified. She's not a police officer. She had no arrest powers in bold. This is really bad for the state. Nobody legally told her to stop Mr. Herring's vehicle. Yeah, this is going to get overturned. Like, the odds of a case getting overturned are very slim. But this case, I mean, Brian Steele is really, really good at making these arguments. I assume he's going to argue tomorrow since he didn't write the brief. I think one of his strongest suits is arguing that trial counsel didn't raise inappropriate affirmative defense. We've seen him do that in several of his arguments that I've covered on this channel. Defensive habitation versus self-defense. I really thought citizen's arrest was just a thing in the movies. It's trending that way. I don't know if you guys know this. Yeah, there's a thing called the American Law Institute, the ALI. They write these things called restatements, which is basically summaries of applicable law across all 50 states. They basically are intended to reflect the state of the law across all 50 states. I actually worked for the ALI after I graduated from law school. I helped write part of the third restatement of torts. And there was quite a bit of discussion about eliminating citizen's arrest entirely from the third restatement. It's definitely on the way out as a trend nationally. I started to look something up, and now I can't remember what I was looking up. Oh, yeah, I remember now. I wanted to show you. Here we go. This is to my point that cases are very rarely overturned. Where are you? There you are. You can't see that very well. These are the opinions that came out today from the Georgia Supreme Court. These are essentially all criminal cases, except for this one case of attorney misconduct. Summaries of opinions here. There we go. Woo! There you go. They were all upheld. We have, let me see, this is like all Atlanta. Chatham County isn't. I don't believe. Everything else is Atlanta. There was one case, Sims versus State, that got remanded to the trial court for further consideration. But other than that, literally everything was affirmed. Every conviction was affirmed. It's very difficult to win on appeal. You guys probably all know that, but just, you know, FYI, very difficult. But this one is looking very, I would say, looking very good for Ms. Payne. The state really didn't do itself any favors. Dang, disbarred, is that embarrassing? I mean, it's not ideal. Did this one get disbarred? Let's see. Yeah, he got disbarred. What did he do? State Bar alleged that Singleton was hired to represent a client in a probate matter and stopped communicating with the client and performing work in his case. Yeah, ghosting clients is a good way to get disbarred. They generally don't like that. Oh yeah, he did it again too. So yeah, he got disbarred for ghosting his clients. That is the thing that happens sometimes. Okay. During that false imprisonment, he was shot by the defendant, again causing a gunshot wound to his abdomen, which caused the murder. False imprisonment was complete, felony murder. The state went further, pointing out that if the imprisonment was unjustified, Ms. Payne would be the aggressor. Don't do it to Sarah Boone. I low-key want to represent Sarah Boone because, hear me out. Or the crazy one is what's his name? The guy that had to hold up the objection sign because he was talking too much. Because if I were to represent Sarah Boone and I win, that means I'm better than all of the attorneys that came before. Which means I'm beating 15 attorneys, all Daryl Brooks. I knew it was a D name. So that means I'm not only beating the defense lawyers, or not beating the state's lawyers, I'm also beating all of the prior defense lawyers. So that's 16 dubs just all at once. And you can't beat that. How is she going to fight the video? I have no idea. I deserve better. Yeah, she's not really the type of client that I typically represent by any stretch. So this was not a subtle or unspoken problem with trial counsel's choice of instructions. Totally agree. As the state repeatedly told the jury as instructed, even if Mr. Herring tried to grab Hannah into his truck and kill her, he was justified and she was not. The jury could only acquit to the extent that her actions were in self-defense. And as trial counsel admitted, there was not a good argument that Payne was defending herself when she stopped his vehicle. Yeah. Properly instructed, of course, the jury could have found Ms. Payne used no more force than was necessary to prevent an impaired driver from fleeing the scene of the crime. Just as door security can detain someone temporarily to keep them from fleeing with stolen goods, Payne was justified in pulling her Jeep in front of Herring's truck so that he could not flee, and asking him to step out of the car so he could not ram her vehicle. Nor is the evidence of guilt overwhelming with this theory available. Indeed, while the state called multiple witnesses, their accounts were so at odds with each other and with their previous statements that the state explained in closing that trials are not a memory contest. I hate when they say that too. For instance, Ms. Rosser and Ms. Jackson, who had the most state-friendly version of events, testified that Mr. Herring took no steps at all to defend himself. In their telling, Ms. Payne started beating Mr. Herring, threw herself into the car, he accelerated, and she shot him without his taking any actions to defend himself. But Ms. Payne's shirt was torn, she had injuries, there was male DNA on the gun. This is not consistent with a one-sided struggle. And Ms. Rosser's version of events had Ms. Payne threatening a bystander into fleeing with a gun, a detail corroborated by no one else, and suggesting that Ms. Rosser might have wanted to prevent the version of events most likely to lead to conviction. Indeed, the state took seriously the possibility that the jury would find Mr. Herring and Ms. Payne were engaged in a life-or-death struggle, telling them you can't poke a bear and then when the bear turns around and attacks you, want to claim self-defense. I don't know. If it's a bear, I don't know. I feel like if you just poke a bear, because bears are really strong. Is she asking for a new trial? Yeah. Yeah, I don't really know the facts of the case, Big Playboy. I'm just going by what's in the briefs. I usually try to do it that way on appeals, unless I watch the case originally. I'm sure the state's going to get into that in their brief that we can take a quick look at next. If Ms. Payne was justified in detaining Mr. Herring as part of a citizen's arrest and justified in telling him to get out of his car, then she could be justified in responding to his efforts to drag her with his car or reach for a weapon with deadly force. In short, the successful prosecution of this case hinged on the idea that it was illegitimate for Hannah Payne to attempt to prevent Mr. Herring from fleeing police. Trial counsel failed to take any steps to properly instruct the jury that Ms. Payne, like any law-abiding citizen, had the right to detain someone who committed a crime in her presence. Properly instructed, there was a reasonable probability of a different result. It'll be interesting how this played. Yeah, definitely. I would be surprised if she gets a new trial, just because the trial counsel definitely should have requested these instructions. Didn't we add a bear to the Richard Allen appeal? We did. Well, I did. The state did. Trial counsel erred by failing to seek an instruction on defense of others. As confusing as trial counsel's failure to request instruction on citizen's arrest was, his failure to request an instruction on defense of others. As confusing as trial counsel's failure to request an instruction on citizen's arrest. Oh, I get it. Was his failure to request instruction on defense of others. I read that wrong. Why did you not request a defense of others charge in this case? I don't think there was that much of a nexus combined to Ms. Payne and the driver of the truck. When asked to clarify, trial counsel explained his legal understanding that you cannot ask for defense of others instruction if the defendant does not know the people she is defending. Look, I'm trying this new standing desk, and I really like it, because sometimes you just kind of have to walk away. And that's one of those moments. What? I mean, it's probably easier to make the case if you know them, but... And I'm not saying she's not guilty. Maybe she is, I really don't know, but that's an angle I'm not familiar with. This is wrong. The justification statute has no such requirement. A person is justified in threatening or using force against another when and to the extent that he or she reasonably believes that such threat or force is necessary to defend himself or herself or a third person against such other's imminent use of unlawful force. If the General Assembly wanted the law to apply only to friends and family, it would not have used such a broad term. Yeah, that's weird. What did he say again? I don't think there's that much of a nexus. That's strange. Even at common law, you could act in defense of a stranger's life. C.E.G. Williams v. State from 1943, explaining common law rule that you may act to defend a stranger. To act in derogation of that common law, you would need textual support in the statute. So, for instance, this court has held that when a defendant found a victim, in quotes, so, firing a high-powered hunting rifle at the back of a church's chicken in the dead of night, he was entitled to shoot that victim in defense of others. C. Murph v. State, 251 Georgia 478 from 1983, reversing conviction for voluntary manslaughter because no heat of passion and because defendant was justified in protecting strangers in parking lot. No, not a Waffle House. I'm sure Cheryl McCollum will be able to solve this one, though. In other words, the nexus requirement for defense of others was invented by trial counsel. There is no support for it in any statute or legal opinion that we could locate, nor does it seem that anyone has ever even argued that it is true since the passage of 16-3-21. Under Georgia law, you can defend people with no requirement that you make friends first. That's kind of funny. I like the way Andrew laid that out. Hinders the state ability to argue strategy. Yeah, true. How strategic can a decision be when it's rooted in a fundamental misunderstanding? Yeah, I think he did that for both arguments. I think Andrew, he tweeted about this recently, maybe a couple months ago, about how it's helpful on a motion for new trial, in a motion for new trial hearing when you're questioning lawyers, just ask them to start by asking them to explain their understanding of the law rather than asking them why you did something. Because if you ask a lawyer why they did something, they're generally going to be good at coming up with a reason for it. But if you first ask them their understanding of the law and then they don't understand the law, you don't even really need to get into their reasoning, which is really smart. I mean, it's Andrew, so of course it's smart, but that being said, if you're a good defense lawyer, you should hope to be found ineffective in a given case, because that means your client gets a second chance. People make mistakes. No need to take it personally. I mean, not me, but other people. As discussed above, when trial counsel fails to research a basic point of law, that is deficient performance. And in case after case, this court has held such deficiencies entitled Georgians to new trials. Under Strickland, we evaluate whether trial counsel's decisions are reasonable based in part on whether they result of an adequate investigation. Under no circumstances can failure to read the relevant statute be strategic. Obviously, much of what Ms. Payne was doing on the day of Mr. Herring's death was not being done in self-defense. She was not acting in self-defense when she followed Mr. Herring to get his tag number, or when she pulled in front of Mr. Herring's truck to prevent him from fleeing or striking anyone else, or when she told him to get out of the truck so he could not cause any more accidents on the roadway. Her self-defense only began after she poked the bear, and the bear decided that he needed to hurt her. Okay, I think we're taking the bear thing a little too far. But if those initial acts were unjustified, then, as the state argued, Ms. Payne would be the aggressor and should not be entitled to act in self-defense when Mr. Herring dragged her into his truck and accelerated. For the same reason, the failure to charge 17-4-60, that's the citizen arrest precedents, Ms. Payne substituted the failure to instruct the jury that she was authorized to use deadly force if necessary to prevent Mr. Herring from committing further forcible felonies. Mr. Herring had already caused an accident, driven erratically, and fled into traffic, and Ms. Payne had an objectively reasonable basis to believe continued flight posed a danger to others on the roadway. Nor can the state argue that the threat Mr. Herring posed was not imminent, because Mr. Herring was in the process of using his vehicle to flee at high speed through active traffic while ignoring police commands. The danger to other motorists was not speculative. It was present, ongoing, and therefore imminent within the meaning of 16-3-21A. Sorry, I was thinking about the statute for a second. Every minute he spent on the road could have resulted in serious harm to a law-abiding citizen. What if the bear was Pooh Bear or Paddington Bear? I don't think they would mind a poke. Or the country bears. What other bears are there? You know, now that I think about it, Big Bear kind of has a... Bears seem to have a great PR agent, because all these bears seem very friendly. Let's have that Justin Baldoni PR team. In short, trial counsel's failure to conduct basic research resulted in life imprisonment for someone who is simply trying to stop an impaired driver flooring it in heavy traffic, heedless of the dangers to others, and willing to kill to escape justice. This failure to conduct research was deficient performance, and because this deficiency virtually required the jury to convict if it believed Hannah Payne's version of events, it prejudiced her. Given adequate counsel, Ms. Payne would likely have prevailed, and for this reason, we request a new trial. The state has never disputed that Hannah Payne was trying to help on the day that Mr. Herring died. She did not know whether he was diabetic or schizophrenic or simply a hardened criminal. What she did know was that he posed a danger, and by pulling her car out in front of his truck, she could mitigate that danger. But because the jury was never properly instructed, her trial was rendered fundamentally unfair. We ask that she be given a second opportunity with effective counsel to vindicate her innocence. We could have a talk with Brian at some point. My guy. If Brian updated his email address, he might get some more business. I know he really needs more PR, so it's more publicity. So updating the MSN email address could really be a big move for his career. Could be AOL. I saw an AOL recently. I can't remember who it was. Speaking of Brian, I still need to learned handedness. That's kind of funny. That's a great username. I didn't notice that before. I always heard those lawyers you don't want to mess with. You know, I will say, the best way to tell a good lawyer is if they have, like, if their website is bad, or if they don't have one. Like, I'm looking for Bruce Harvey's website right now, and I just can't even find it. Maybe he took it down. Yes, someone understood this username. Yeah, I just didn't read it all at once. For those of you who don't know, Learned Hand was a judge from, I think, the 20s. He's I don't know, probably one of the most best-known lawyers of the 20th or judges of the 20th century. Not Larry Bruce Harvey from California. Ridiculous. I don't know. I don't think Bruce Harvey might have taken his website down. But his website was not great. Not had a website for at least a year. Yeah, he's retiring. But yeah, it was made by it was like a GeoCities website from 20 years ago. I believe he also didn't need the publicity, I suppose. So this is the state's reply or opposition. What's interesting is it's like 50% longer than the appellant's brief. We're going to skip over the statement of facts, enumeration of errors. Some of it actually, somebody said something about... I'm just going to read the intro. Summary of the argument. The jury was properly instructed, and this case was not tried on an incorrect theory. The trial court accurately instructed the jury on justification, including self-defense. the only defense theory supported by any version of the events. Payne's claim that the jury should have been instructed on citizen's arrest in defense of others fails as a matter of law. Defendant is not entitled to a charge unsupported by the evidence. Georgia courts have repeatedly held that a citizen's arrest instruction is inappropriate where the defendant's use of force is unreasonable, where the defendant is the initial aggressor, or where there is no evidence that a forcible felony is being committed. That is exactly the circumstance here. Nothing in the record suggests that Payne was attempting a lawful arrest. The evidence showed the opposite. She pursued after being told not to, boxed him in, and confronted him while armed and initiated a physical assault. Herring was unarmed, not violent, and not fleeing any forcible felony. Under these circumstances, neither citizen's arrest or defense of others. Okay, here in the footnote, they're admitting that the trial defense lawyer was wrong about the law. So that's something. I don't know if I'd put that in a footnote personally. Yeah, they're admitting that the defense counsel didn't understand the applicable law. That's tough. I'm guessing they're not going to address that elsewhere. The state never disputed that Payne believed she was trying to help, but her belief does not justify her actions under Georgia law. Payne's assertion that the state never denied she was trying to help is legally irrelevant. A subjective belief, however genuine, that one is helping or keeping the community safe does not authorize unlawful pursuit, physical aggression, or deadly force. Georgia law does not permit private citizens to chase, confront, assault, and shoot unarmed motorists based on perceived impairment or speculation about criminal activity. The reason deadly force is tightly constrained is to prevent exactly the kind of vigilante escalation in which Payne engaged. The jury was properly charged with determining whether the state met its burden to disprove self-defense beyond a reasonable doubt. The evidence showed that Payne's use of force did not satisfy the statutory requirements for justification, thereby disproving any claim of self-defense. Well, yeah, I mean, that's not really in dispute. Payne's version of the encounter is flatly contradicted by the evidence. Payne claims that Herring grabbed her by the neck, dragged her inside his truck, and struggled for a gun, but not a single eyewitness corroborated this account. Not one person saw Herring attack her. Every witness testified that he was unarmed and not aggressive. The medical examiner confirmed bruising to Herring's chest consistent with Payne's assault, and the physical and forensic evidence firmly contradicted Payne's description of the shooting. The evidence exhibited a one-sided confrontation initiated and escalated by Payne. 4. A citizen's arrest in defense of others theory was not only unsupported, but it was directly refuted by the evidence. Payne was the aggressor. She used unreasonable force. She pursued after being expressly told to stop. She blocked Herring's vehicle. She threatened him with a firearm. She physically assaulted him through the window before firing the fatal shot. There was no ongoing forcible felony being committed by Herring. He was not an imminent threat to anyone. Yeah, this is a tough claim to make. This is at least a question for the jury. Even if you agree with it, I mean, there was a prior collision, and it seems like he was having, at the very least, some kind of diabetic episode. So not an imminent threat to anyone is definitely a difficult argument to make. Yeah, Aaron says, so she might get a new trial and then likely to get convicted again. I could see that. Isn't it a question for the jury whether force was unreasonable? Yeah. No reasonable basis to believe deadly force was necessary. Under Georgia law, these facts foreclose citizens' arrests in defense of others' instructions. Any claim of instructional error fails under Strickland in harmless error principles. Even if Payne's proposed instructions had been legally viable, which they were not, she cannot show prejudice. No reasonable jury could have acquitted her under a citizen's arrest or defense of others theory, given the unrebutted evidence of her aggressive pursuit and unjustified escalation to deadly force. The verdict did not depend on the absence of an instruction, it depended on the strength of the evidence. Therefore, Payne received a fair trial under the correct legal standards. The jury was properly instructed. The evidence revealed that Payne pursued, confronted, assaulted, and killed an unarmed motorist in violation of explicit police instruction and without lawful justification. The conviction did not result from an erroneous charge, but from Payne's own conduct. Payne's attempt to recast vigilante actions as community protection finds no support in the law of the evidence. The trial court's judgment should be affirmed. Bench trial, if you have reasonable expectation the judge understands the law. Yeah, I generally think that you want to go with a jury trial, if at all, if possible, but I could see that in this case. Okay, this makes sense. Earlier when I was talking to myself, I was wondering about these counts and why they didn't merge, but I guess they did. Okay, that all makes sense. I think a bench trial helped save Cole Goldberg last week. Yeah, definitely. Are judges elected in Georgia? Yeah. I believe they're initially appointed and then they're elected after that. But yeah, there are actually elections coming up, I think. Judge Whitaker, for example, is running again. There are a couple others that are running opposed. Oop. Supreme Court justices are running right now. I believe Hawkins is being opposed. And who's the other one? Bethel, maybe? Medical witness for state admitted no evidence Mr. Herring was having a medical episode for a tragic incident. Yep. Let's read through the facts. We just read the arguments, basically, the summary of the arguments. I don't want to go through this whole thing because my voice is getting tired and I want to watch the oral arguments. So let's just read through the facts because I know there are some questions about the facts in the chat, and I said I would get through those. So here we go. While Payne's statement of facts recounts portions of the trial testimony and evidence, albeit presented in a light most favorable to the defendant, it conspicuously omits material facts necessary for full and accurate understanding of the record. The state therefore submits the following clarifications and additions to assure a complete and balanced account of the evidence. Bro, just do it. You don't have to say all that. Statement of material facts. On May 7th, 2019, Hannah Payne witnessed Herring when a red light. She pulled over, contacted 911, began speaking with the semi-truck driver as well as a witness, a Georgia DOC officer. Payne testified that after collision, Herring exited his vehicle, then re-entered it and left the scene. She attempted to obtain his license plate number, but was initially unable to do so. According to Payne, the DOC officer motioned for her to follow Herring. Although Payne asserted that 911 never instructed her not to pursue, the transcript of the call contradicts this. The dispatcher repeatedly directed her not to follow Herring, and Payne acknowledged these instructions, but continued pursuit, later claiming she was not chasing, she was catching up to him to get the tag. After obtaining the license plate, Payne insisted that both vehicles return to the accident scene. Payne told 911 she intended to remain with Herring until police arrived, stating that she felt safe doing so. Cops should not have told her to pursue him. Yeah, probably. See, now I'm wondering when Learned Hand was a judge. I'm second-guessing myself. I was right. I know stuff. He served as a federal trial judge in the SDNY from 1909 to 1924, and as a federal appellate judge on the U.S. Court of Appeals for the Second Circuit from 24 to 61. It's 52 years as a federal judge. Not bad. I'll just share this real quick. Where are you? This guy. If you go to law school, you will be very familiar with Learned Hand. There's one case, I wonder if it's in here actually. Let me see if I can find it. There's like a high-profile case section. Authored approximately 4,000 judicial opinions during his career. Admired for their clarity and analytic precision, they have been quoted more often as Supreme Court opinions and by legal scholars than those of any other lower court judge. Carol towing, yeah, that's definitely one of the cases that comes up that I read in law school. Founding member of the ALI, I mentioned that earlier. Developed the influential restatements of the law. But yeah, so that explains the learned hand knits. Apparently was some sort of math proof test. Yeah, that was respect to negligence law. Oh, I'm gonna fix this real quick. There we go. The rest of my brain. It'll do that. That'll happen. What is it? BPL, I think, was the equation. Next stream, every time Jim gets distracted, he has to take a shot. It'll be a fun time had by all. I'll be dead. But I guess I'd stop getting distracted at some point. Why were lesser charges not offered? I'm guessing they just didn't want the lesser charges. Sometimes if you offer, it can be counterproductive to offer lesser charges if you're going for the highest level. If you want like a murder conviction, you don't want to offer manslaughter just because you don't want the jury to fall back to that. That was like a compromise. Okay. Payne then approached Herring's vehicle holding her cell phone. She claimed that Herring knocked the phone away, grabbed her wrist, and pulled her into the truck. Payne further stated her firearm holstered at her hip was removed during what she described as an effort to defend herself. She further claimed that during the ensuing struggle, Herring allegedly pulled the trigger, causing the fatal shot. Cross-examination revealed significant inconsistencies. Payne admitted that she did not speak with Herring at the original accident scene, never saw a weapon in his hands, and was not threatened by him prior to the shooting. Payne also conceded she heard and understood the dispatcher's repeated instructions not to pursue. Additional contradictions arose concerning how Herring stopped his vehicle. Although Payne denied cutting Herring off, multiple eyewitnesses in the physical evidence indicated otherwise. She also denied telling Herring to get out of his car, yet the 911 audio captures her shouting precisely that command. In her recorded police interview, Payne acknowledged that her finger was on the trigger at the time of the shooting, and that the gun was resting on the car window, not pointed away from Herring. She further conceded that Herring had nothing in his hands. Finally, Payne admitted that the entire encounter was avoidable, and that she voluntarily placed herself in the situation. That kind of seems to play into the citizen's arrest stuff to me, though. She admitted threatening to shoot Herring, asserting it was intended only to deter him. Yet she testified that she was not bluffing. Payne concluded that the shooting occurred only because Herring tried to take her gun, and absent that struggle, she would not have drawn the weapon. Terry Robinson, a DOC officer with 8 years of experience, including those medical conditions, testified that he was familiar with symptoms commonly associated with diabetic distress, including glassy eyes. On the day in question, while off-duty, Robinson also observed Herring's maroon truck collide with a semi. When Robinson approached, he observed Herring slumped over in the driver's seat, appearing dazed and confused. He immediately called 911 and remained at the scene. Robinson testified that nothing about Herring's appearance or behavior suggested intoxication. He specifically noted Herring's glassy eyes, confusion, and the absence of any alcohol. Based on his training experience, Robinson concluded that Herring was experiencing a medical emergency. Fair enough. Due to Herring's ongoing disorientation, he placed a second call to 911. Despite the visible damage to Herring's truck and his apparent distress, Herring exited the vehicle, wandered around the scene, re-entered the truck, and attempted to leave. Robinson told Herring he could not leave. Nevertheless, Herring drove away, further demonstrating confusion rather than criminal intent. I don't know if I agree with that conclusion, that inference. Robinson testified that Payne had no interaction with Herring at the accident scene and played no role in the collision. He identified himself as an off-duty state officer and advised bystanders that emergency assistance was en route. 2 words. After Herring departed, Robinson asked the semi-driver to photograph the license plate. Robinson expressly denied instructing anyone, including a Payne, to pursue, detain, or use force against Herring. Robinson consistently reiterated that Herring's conduct, both at the scene and in leaving it, was consistent with a diabetic mental episode, not intoxication, aggression, or threat justifying the use of force. Sister, again, this was, I believe, said in the appellant brief. Multiple eyewitnesses testified that Payne escalated the situation aggressively. We covered this already. Yeah, I could definitely, if accepting these facts was true, I could see a new trial and a new conviction. It's definitely possible. Thugged out again. That's wild. I don't know. Serial killers get a lot of years in Georgia. Nobody ever gets parole for murder in Georgia. It's crazy. Yeah. Okay. I think we've seen enough to be prepared for tomorrow's oral argument. I want to switch to the to Kat's. We're going to do a joint watch with Kat, even though she's not here. Oh. Jeez. The dog's really excited for oral argument, I guess. All right, here we go. Which one are we going to do first? Anthony Sims or Daryl Ewing? I think Anthony Sims is the one where the judges yell at, "Show us the dog." Oh, he's eating now. I can't get him. I'll get him in a second. Should I do Daryl Ewing, or if you guys are familiar, should I do Derico Devin / Daryl Ewing or Anthony Sims? Yeah, of course, friend. And I'm not an expert on this case at all. I'm just reading it mostly for my own edification, just so when we watch it tomorrow, I'll have some idea what's going on. But I'm sure there are plenty of you who know more about this case than I do. I'm not trying to say I'm an expert by any means. Hey, Kat, you're here. Which one should I watch? The Ewing? I'm kind of leaning towards Sims. Sims is the yelling. Ewing is the especially ridiculous arguments by the state. Oh, man, that's tough. I feel like we'll do Ewing since you did that one first.
Doing something and finding that someone wasn't acting in bad faith or not doing something in bad faith isn't really the same thing.
Sims has a great appellant argument. Do Ewing? Okay, I'll do Ewing. All right, give me 1 second though. I want to switch my desk around. I want to sit down. My legs are tired. Whoa, not you. I switched my background to green for no particular reason. Ooh, I know. I know what we'll do. I'll slide me over here. That way we can do a reaction to Cat's reaction. I hear me. Oh man, you guys are going to see my messy couch. That's okay. Ugh. No! Okay, there we go. Come on, desk. Ah! Oh man, I'm still getting used to this guy. Okay, here we go. Lower this a little bit. Is this a meme? I'm not sure what you're referring to, but probably. Okay, let me know how the sound is. We're going to watch Cat's introduction to this case. I did ask permission beforehand, just so you know. I'm not just stealing her content. But I don't know anything about this case. Watching the desk lower in real time. Yeah, probably. I was intending to stand for the whole stream, but, you know, I'm getting a little tired.
Hey. We are going to be looking at oral arguments, which I always love listening to. Sometimes we just jump right into them. But with this one, I think we're going to get some backing context before we jump in. So we're going to be listening to Michigan Court of Appeals oral arguments. I think that's going to be a good time.
She's right.
This is centering on a case involving two individuals, Derek O'Searcy and Daryl Ewing, who are pictured here. They've been for like a decade and a half now all over the appeals process. And judges have been like, hey, there were issues in the original trial. A new trial's been requested. There were issues with the new trial, though, and on the eve of trial, a dismissal was granted. Like, we just got a lot going on. So rather than trying to give you a quick summary, we're actually going to read a little bit more in depth than we usually do. So getting right into this, you guys, hello, as you come in, please hit that like button. Let's get the background on the case itself.
That's right. Hit the like button on my stream, though.
The appeals process that got us here, and why we're ultimately seeing the state ask the Michigan Court of Appeals, please undo the trial court judge's decision dismissing our case. Please undo that decision. We're going to watch them argue that. So the incident and arrest, we're going to go all the way back to 2009. We've got on August 16th, 2009, a shooting occurred on Detroit's west side. So we're in Michigan, resulting in one fatality and multiple injuries. Daryl Ewing and Derek O'Searcy were identified by law enforcement as suspects in connection with the incident, which was characterized as gang-related. So, you know,
as
common
always.
motif over here on this channel.
The dog has stayed out of lockup. The 12 has not spelled his name incorrectly recently, so that's good news.
In the cases that we talk about. Following the shooting, both men were apprehended. Their arrest would mark the beginning of a lengthy battle. So, yeah, it's going to be a time. So, the case itself. We have J.B. Watson and his girlfriend, Larita Thomas. They're in Thomas's van, another individual, with Philip Reed and Willie Williams. Reed and Williams were cousins and members of the Knockout Boys or the KOB gang. A turquoise vehicle approached the van. According to prosecution witness Raymond Love, there's a love in this trial.
Oh, Lord.
The passenger, who was allegedly Ewing, exits with a handgun, fires multiple shots into this vehicle, and then fled as the driver, who is allegedly Searcy. So it's supposed to be Searcy and Ewing in this car, and Ewing's the one that gets out and shoots at this other vehicle. And they speed away. At the trial, prosecutors argue that Ewing and Searcy were in a rival gang. So we have KOB and we have the Hustle Boys gang. And Ewing and Searcy are apparently, according to the prosecution, part of Hustle Boys. And it's supposed to be this retaliation, this back and forth for a feud that's been going on during this point in time back in 2009. The defense says, well, no, there's actually no direct evidence linking our clients, these co-defendants, to these gangs beyond inferences. But they're ultimately arrested shortly after this incident, I think in December. Yeah, December 29th, 2009. One of the victims dies, so that's why we're getting serious charges here.
That's crazy. One of my cases actually had something happen on that exact date. Random.
Another was injured, and then the two other passengers in the vehicle was shot up.
That's not true. It's 2008, exactly 1 year before.
Were unharmed. So there's a little bit of the case background. The evidence that they relied on, they have Raymond Love's identification, and then cell phone records placing them near the area of the scene. So the trial itself. Ewing had the more serious charges. So he's got first-degree premeditated murder. He's got 3 counts of assault with intent to murder. He's got possession of a firearm during a felony. And Searcy has second-degree murder and 3 counts of assault with intent to murder under like this accomplice aiding and abetting theory because he was driving. This was in Wayne County Circuit Court. The judge then was Vonda Evans. I don't think we'll really hear her by name, but if they ever talk about the trial court while we're watching these oral arguments, they're referencing all the way back here to 2010. So Judge Vonda Evans, prosecutors relied on eyewitness testimony, the original trial court, not the trial court with the dismissal. So they rely on witness Love, the testimony. The motive was this gang retaliation, and they have some forensic evidence, like the cell phone location. And Karen James.
Okay, I don't want to go through the appellate history. I just want to get the factual background. Now we're going to go to oral argument. Here we go.
Should be available, which is a good thing we didn't watch it when it actually happened because
the Michigan Court of Appeals only has 3,000 subscribers. If I could pass the Michigan Court of Appeals, that would make me happy.
There weren't closed captions available when I pulled this up yesterday. And let's see.
Put them in their place.
And hey, everybody, by the way. Hey, everybody. Yeah, 15-year pattern isn't like, oops, we forgot to do our homework. Yeah.
Here. Court of Appeals stated that is now in session. The Honorable Brock A. Schwartzel, the Honorable Philip P. Mariani, and presiding the Honorable Seema G. Patel. All persons having business herein draw near, give attention, and they shall be heard. God save the United States, State of Michigan, and this honorable court. Please proceed.
Good morning. Welcome to this session of the Court of Appeals. I am Judge Seema Patel, and I have the pleasure today of sitting with Judge Brock Schwartzel and Judge Phil Mariani. Before we get started, a couple of I guess, housekeeping rules. Has counsel for the first case decided how they want to allot time for argument?
Can assume that the order. Answer people.
Oh man, I get distracted by 2 chats. This is going to be tough.
Okay.
I love the Michigan seal.
I think that did we grant oral argument to Mr. Ewing?
No, Dom was.
You are preserved. Okay. Okay. So, because this is a consolidated case, I'm not going to go back and forth. I'm going to have the prosecutor give their argument and then have the defense for both cases give their argument. And I don't know if you've had a conversation of how you want to split up that time between the two of you. It's 30 minutes.
It's because there's 2 co-defendants.
20 for you, 10 for you. Okay, great. And then you will have time for rebuttal. Thank you very much. We will begin. I'll call the case. Item number 5, docket number 370807 and docket number 370809. People v. Derrico Devon Searcy and People v. JRobichaudEsq Ewing.
The captions are horrible.
Good morning. May it please the court. Dan Hebel on behalf of the people of the state of Michigan. Now,
Well, let me move the caption so we can
The
see the
basics
gallery.
are all in the pleadings. So I'm going to point out some things, but I just want to let the court know, anytime you have questions, please, that's why I'm here. Okay. Is to make sure that all the court's questions are answered. This case is not about a discovery
This is already off to a great start.
violation. And this case
It's making me think it is about a discovery violation.
is not in compliance with either Brady or Youngblood. And
I thought it said young boy for a second.
that's why the people are a bit baffled by the case. In just in general, why we're here. Because
You explain why there's not a discovery violation here.
absolutely. The court didn't find a discovery violation. The court found a due process violation. If there was a discovery violation,
I mean,
then we go through the standards of discovery violation. We deal with that. There's a lot of different types of relief that the court could have imposed for a discovery violation, and these escalate. Okay, first off,
okay, like, first of all, unless I'm missing something, discovery violations are due process violations, right? Am I missing something? It's not like they're not distinct. I believe all due process or all Brady violations are due process violations, or all discovery violations are generally due process violations. But of course, not the opposite isn't true. Not all due process violations are discovery obligation or violations. But I don't think that's like a mutually exclusive. I'm just confused by that. I mean, I'm not confused. He's confused by that.
the people asked for more time. We wanted more time.
But you took that off the table. You revoked or you took back your motion to adjourn.
The
This is
people
going well.
the people have been under the understanding.
No, it is not.
This is okay. Rate this on a scale of like 1 to 10 on how well this is going for the state so far.
1.
We are, with all of that intro, because it was like 3 minutes of intro. We're like a minute into this of actual argument.
True. It's not good.
that the court was not going to grant it.
That's not an excuse. I mean, you took it off the table and didn't make the trial judge actually rule on the motion, and then that's on the prosecutor. That's not on the trial judge.
And even so,
I would just love to see a defense lawyer, to see the state's response if a plaintiff's or if a defendant's appellate attorney made the argument that a withdrawn motion constituted a preserved error. They would lose their minds.
even so, if the now, I want to back up and I want to say,
I bet you do.
even so, we don't want to blend two different cases together. There were problems with the first case. And
What is the first case?
okay, the first,
I mean, use the names. Ewing or you mean
my
the first case?
apologies. The first
original
trial,
trial.
the
I got
first
you.
trial of both.
I told you
defendants.
it'd be confusing.
There were problems with it. It got reversed. It got to a new team that had no idea about it. New prosecutors that were going in cold because the old prosecutor retired. And they were trying to get everything together. And they thought they had everything together. And then they were asked for more things. And they didn't necessarily know that those things existed. They found new stuff and they provided it. They were
So the state knew that it existed. I hate when they play this game. It's not about whether the prosecutors know something exists. It's about whether the state knows something exists. They play this game all the time.
providing right up to the very last day. And quite frankly, if the court found
What?
that not enough stuff, that there needed to be more provided.
Is that timely to hand over
No.
discovery stuff up until the very last day?
No, he said
Let's
that
see.
exactly. He said that like he should get credit for turning stuff over to the very last minute when that's not really how it works. That just means you didn't turn it over in a timely manner.
It was like you had 15 years.
Exactly.
Like, unless the thing just came about the night before, why are you turning it over up until the final day?
Then
Oh, Lord.
the obvious answer would be to tell the people to provide it and adjourn it.
It's not the judge's job to tell you.
Or even if not, tell the people that they were limited in what they could use.
And then took it away.
To things that were
How about you turn over the evidence?
Not in question. But none of these remedies were considered. The court did not.
The court did consider the requested jury instruction, though, right? And explained why, in the trial judge's opinion, that jury instruction request is not sufficient.
Mm-hmm.
Okay, so the trial judge did consider.
Yeah, the conversation between Past Cat and me is it's pretty fun for me too.
Lesser alternatives.
The trial judge did consider lesser alternatives, but the trial judge was not approaching this from the point of a discovery violation. And that, if we had been able to argue from the point of a discovery violation, if we had been able to offer other remedies from the approach of a discovery violation, then this is a different conversation that we're having.
Counsel,
here.
I mean, what foreclosed you from providing a wider range of options to the court?
The court holding that it's a due process violation. When you have a due
But
process.
did the court limit the arguments you were able to present?
Quite frankly, if you look at the transcript, okay, the court stated the problem. We have not a discovery violation. We have a due process violation. Tell me what you think. We objected. We disagreed. We don't believe that there's a due process violation because, quite frankly, it doesn't meet Brady and it doesn't meet Youngblood. And then the defense said, well, yes, there is a due process violation. The court, after framing it as a due process violation, found it was a due process violation. So yeah, our arguments were limited when we come in and the court says, this is what's wrong with your case. You are in violation of due process.
I mean, whether the label is due process or something else, it was all based on discovery.
Yeah.
It was all based on questions about discovery.
It can be both.
And the prosecution had put on the table potential adjournment and then almost inexplicably took that off the table. And I don't understand the suggestion, well, the prosecution.
Almost inexplicably. So this guy is just repeating the same thing he tried to question on earlier. He's like, but no, wait, like you're arguing this. It's not discovery, it's due process, but the due process violations are like umbrellaed over a bunch of different discovery violations that were found. So it's just encompassing of those things.
That was
and if you needed more
than how I
time,
put it.
you'd ask for an adjournment, but then you rescinded it.
Yes.
So that's your own fault. And he already called this out like 2 minutes ago. And then
Yeah, the state's attorney was saying that the judge did not consider lesser alternatives, but the judge couldn't because they withdrew the lesser alternative motion.
he says almost inexplicably, like there's no reason for it.
We thought we were going to lose it, and so we just took it off the table. Why? You see trial judges having to make calls all the time. I don't understand why that was taken off the table, but at least an adjournment and a jury instruction was considered during that hearing. And you took the adjournment off. The trial judge explained why the jury instruction wasn't sufficient. Why wasn't it completely reasonable for then the trial judge to say, we're going to dismiss these cases without prejudice? You can bring the claims again or the charges again. Why wasn't that a reasonable approach to whether it's a due process based on discovery or just discovery violation?
Because any termination of the case is in fact the top sanction that can be imposed.
Well,
and I understand
two different ways
No.
to dismiss.
Wouldn't the top sanction be dismissal with prejudice?
Yes.
Of
So
course.
this is not.
So,
So this is not.
but it is.
Excuse me. Yes. This is not the top.
Yeah, don't talk over judges. They
Just
don't like
getting
that.
demolished.
Violation.
Because any termination of the case is in fact the top sanction.
That's just incorrect. Not any termination of a case is the top sanction. Cash just said this, but termination with prejudice is the top sanction. Not any termination. This is unserious.
That can be imposed. And I understand it.
Wouldn't the top sanction be dismissal with prejudice?
Yes, of
So
course.
this is not, so this is not,
But it is,
excuse me. Yes. This is not the top remedy that this trial judge could have imposed.
it
No.
is absolutely. Now, perhaps I misworded it, but I categorize a dismissal as the top with, once again, of course, a dismissal with prejudice as even higher penalty.
Yes. So you just
But-
restated his question.
And the
and agreed
way
with
this
him.
camera, if you guys are not watching, if you're just listening, I think this court has like, I don't know if it's motion activated because I don't know what movement they made, but the way it cuts to the different pans, it's very hysterical to me the way that this just panned to the 3 panel of judges just sitting there staring when he says, but.
Penalty. But
But the dismissals themselves don't foreclose the refiling of charges.
that is correct. The dismissals do not foreclose the refiling of charges.
Yes.
The issue is once again that if this had all been framed as just a discovery issue, if that's what we were discussing, a discovery issue,
Okay.
then things are very different. If
How
we're
so?
talking,
How? You can dismiss the case without prejudice for a discovery violation. So how's it different?
6.201. Okay. There are all kinds of things that we can go to discuss.
Okay.
Yes, there's an adjournment that we could go with. We could go with jury
This guy's
instructions.
over it.
We could go with limitations on what the prosecutor is allowed to present. We can go with other types of things as provided by the court.
I guess the trouble I'm having, counsel, is it seems like, I mean, I understand the due process argument you're making. But ultimately, the court had a problem that it was trying to solve, right? That involved discovery. And I guess what I don't see is why you couldn't, in the
That was funny. Kat was right. They just randomly cut to the other judge just looking annoyed.
discovery. And I guess what I don't see is why you couldn't, in the context of that hearing, say, listen, judge, there's not a due process issue here, and here's why. And if you're looking for other solutions, these are different ways you can handle, a non-constitutional discovery issue. We have this, that, and the other thing, and maybe this also. And it seems like, I guess I'm having trouble seeing why, what the court did here, in the context of the issue it was presented with was an abuse of discretion, just given, the way that it handled and given the arguments that it was actually presented with deciding. And, as, Judge Schwartzel has pointed out, the adjournment issue was there, but then not.
Yep.
I can't represent the mental workings of the trial prosecutors below.
I think I was more prepared for this stream than this guy was for this role.
Yeah, I mean, that's your team. So maybe ask them what their mental impressions were before you
And
come to the Court of Appeals.
Like you guys had recommended, and you just said David Ewing. I don't think anyone mentioned the co-conspirator, the co-defendant. But I feel like I did more prep for this stream.
You did.
So we could have a backing of what was going on than what we're getting here from the state. That does not inspire confidence.
Or trial counsel in general. I mean, the record that we have is the record that we're stuck with. And
So your record sucks.
it would be nice if
Look at the lady's face. I forget her name. If we watch more from them, I'll learn their names.
stuck with.
Watch
And
her. It's real quick.
it would be nice if I could
She's like,
look into the mind, or even if I had a transcription of what happened off the record, with discussions with the defense, with any potential sidebars. All of that would be great.
This doesn't help you. You're the appellant. Like, you need to develop the record. Like, yeah.
But what we have is a record that is extremely narrowly focused on a single issue.
Even if we were to look at this through a due process lens, due process is a very flexible doctrine. You just have to get the process that's due to you, and it can be, formatted in such a way that it deals with the individual problem.
Yeah, this is actually an interesting point. I think I've talked about this once or twice before, but people often think of due process as like a set of remedies. Like A is a due process violation, B is a due process violation. But really, it just means that you're entitled to the functioning of the courts and the laws as they are usually applied, as they're correctly applied. So just because something hasn't been found to be a due process violation in the past doesn't mean it's not a due process violation. It literally is what it says, as the judge just pointed out. Receiving the process that is due, whatever that means under the circumstances.
Problem here all involve discovery. And so even if you couch this in due process terms, wouldn't, one of the remedies that you could have, that the prosecution could have requested is, Your Honor, we just need, if it's a due process problem, we need to give the defendants more process. So let's have an adjournment for 60 days and we'll go back and scour the records again. I mean, there's ways that even if the trial court was focused on due process, for you to make these same arguments that you're making here in terms of there was all kinds of options we could have explored. I don't see how the trial court putting it in terms of due process somehow foreclosed you from making all those arguments about what could have happened.
When the trial court put it in terms of due process, we got shuffled into the issues of Brady and Youngblood. And
oh no,
this is neither Brady.
We got shuffled. What do you mean? These are like critical.
Brady
Lord.
And Youngblood.
We got shuffled in.
And
oh no.
This is neither Brady nor Youngblood. So, because
it's not answering the question.
And this is something that is endlessly.
The question was, why could you not have made the argument under the circumstances that existed? And he says it wasn't Brady or Youngblood. Like, we get it. You're probably wrong, but we get it. Why couldn't you make the argument that you would have made under due process or under a Brady violation? My goodness. 33 people are here on YouTube. Yes, but I'm also taking credit for Cat's viewership. So really, it's like 1,000.
Frustrating. The trial court didn't find that anything was exculpatory.
I should start view botting. My next stream, I'll have 10,000 viewers.
Did not find that at all. And the trial court specifically found that there was no bad faith. The prosecutors were doing their best and actually made a record of that.
I understand that there might be frustration with how the issues were presented in the trial court, but as a prosecutor, you knew that there were discovery issues. You knew that there were issues with the discovery being produced late or not being produced. And why doesn't this just come down to a fundamental fairness issue? I think one of the things that I'm struggling with is that we have a abuse of discretion standard. What was the abuse of discretion in dismissing the cases without prejudice because of these discovery issues?
No,
So the abuse of discretion.
Like, just in general, like, just dismissal without prejudice, yeah, it's like a strong sanction, but just refile. I mean, yeah, it sucks. It's a lot of work to start over, but I mean, it is what it is. If it were, with prejudice, it'd be a different discussion. But
is using due process, either the Youngblood standard or the Brady standard, and finding that the people were in violation of that without the legal cause to do so.
Those are two very specific issues involving due process. But as Judge Schwartzel intimated a few minutes ago, due process is actually a broader spectrum. And I think that, like, how was this not a example of the trial court weighing the issues in front of it and deciding that in order to preserve the fairness of the process and of the case, to dismiss without prejudice? How does that raise to the abuse of discretion?
There's three evidentiary issues that the court was looking at at the time. One was an alleged missing video between the OIC and defendant Ewings.
We stop there.
Yes.
Is it the case that
A missing video.
he wasn't answering the question.
original investigating officer in charge had not been talked with by this group of prosecutors up until the Friday before the trial? Or the Thursday or Friday, the day or two before the trial was to begin?
I am not certain if they had previous discussions. I know that it was indicated that they did at that point. I don't know if they hadn't, or what the logistical reasons would be why.
Well, wasn't the trial judge's maybe a major concern is that this seems to have been the first time that these prosecutors had talked with the original officer in charge, and that this officer in charge alerted them to the very real possibility that a video existed at one time?
Yes.
And isn't that a fairly
The
concerning
audience is nodding
piece
along.
of-
Look.
Yes.
possibility that a video existed at one time?
Yes.
And isn't that a fairly concerning piece of information to be raised the morning of trial?
Yeah, David, I was thinking, like, it's been a little bit of a minute. You came right in here with the good banter with the 15 years comment. Hope you've been doing well. David says he's got to run, but miss watching these with us live. So we miss you too, David. Sorry you've got to run, but hope you have a good night. Thanks for wishing a good night to us as well. Kim's also in the building, says, where do you find these cases? So what's interesting about this one, it just came up on, like, I did a search for, I don't know what keyword I was using, but just to check on different Court of Appeals updates. And I saw the name Ewing, and I was like, the chat had recommended somebody with the last name Ewing a few weeks ago. And I remember, like, writing it down, and I'm like, I didn't really, like, follow up and look at it. So I went and looked at it and realized that they just had oral arguments, and that's why they were coming up in results for, like, Court of Appeals with recent happenings, because the oral arguments was calendared. So last night I tried to organize what I could on this case, get some backing context, and here we are. And I figured it'd be good because this is the state as the petitioner, right? It's the state that has to ask the Court of Appeals to, like, no, please undo something. Please disagree with this currently standing decision. So.
Yeah, I do the same thing. When I'm reading, like, Georgia Court of Appeals or Georgia Supreme Court cases, I'll always jump to state as appellant first, because that's those are usually colorful, regardless of whether they're state ones.
Good to see you too, Kim, and thank you for being a member for 10 months.
No doubt.
Okay, so
what? No doubt?
Morning of turning piece of information to be raised the morning of trial?
No doubt.
Okay, so I mean, I know there's two other things and you can talk about them, but just that alone, wouldn't that be sufficient to say, all right, we need to do something?
Just hit a reset.
And the prosecution had asked for an adjournment. They no longer want an adjournment. So, okay. Jury instruction is not going to be sufficient.
That's reasonable.
Why is it, as Judge Patel was saying, why is it an abuse of discretion for the judge to say, dismiss the charges without prejudice, get your house in order, and then if there's enough to charge again, refile the charges?
It seems pretty reasonable to me.
I'm going to answer that in a bifurcated way.
Oh boy.
First is under the auspices of due process, the due process has been defined repeatedly with evidentiary boxes.
Bro, it's like he's playing the floor is lava with respect to answering the question.
Okay. There's a question that fits in one box. There's a question that fits in another box. There is no box wherein evidence
Put
that
the
is
stick
missing
in a box.
I think he wants to crawl in a
that
box.
is not due to bad faith, that is unknown whether or not it's exculpatory. There is no box that fits into.
Are you
right
going to
now.
answer the question at some point?
Faces in the
And
gallery.
I think that's very important because, quite frankly, there could be potential evidence in any case that is unknown what type of evidence it is, and that is not a result of bad faith. That literally could exist.
Yeah, and that would be a reason to grant a new trial or to dismiss without prejudice. Like, sure, there something could pop up morning of trial. Then you just dismiss without prejudice, let them start over. That makes perfect sense. Also, that don't speak reference and Cass thing was funny. The dot reference, you love to see
any
it.
case. And that's exactly what we had here.
Okay.
We had a video that might be exculpatory
Okay.
or not, and it might exist or not, and it was
Okay.
missing, but not due to bad faith. So,
Okay, and so you dismiss without prejudice and start over.
as far as due process is concerned, due process doesn't touch that. That is a discovery issue.
All right, so
Okay.
let's just look at it through the lens of a discovery issue.
And through the lens of the discovery issue, the easy thing would be for the judge to say, well, in that case,
If he says adjournment, I'm going to delete my channel. If the next thing out of his mouth is anything related to a stay, I'm going to lose it.
you can't bring up gang affiliation at all.
Okay, thank God.
If there's something that might take gang affiliation off the table,
It's not better because now he's just talking about which remedy would be. I mean, in many senses, a dismissal without prejudice is less punitive than an exclusionary remedy. So I'm not really sure this makes more sense.
Really awesome.
okay, and you don't
He did say for the awesome.
you don't provide that, then gang affiliation is off the table. That is one of many remedies that would have worked.
But
Okay.
the prosecution didn't offer that. And I don't think you can just say, well, it was because it was framed as due process, because the prosecution did offer up the jury instruction.
Mhm.
And the judge said jury instruction is not going to be enough. I don't see why the prosecution as an alternative during that hearing could have said, well, Your Honor, we'll take gang affiliation off the table. We will not bring it up during trial. Why was that? I mean, is it just the fact that we've had more time and we've thought about this now? Or
Well,
Would they
quite
have
frankly,
a case without it?
if you look at the transcript, it is short.
Yeah,
It
because
is-
you
it
didn't
is
say the
not.
stuff.
Let's sit down.
Yeah, that's his point. You could have said more. Your Honor, we didn't say the thing, and therefore the transcript is short. And because the transcript is short, you needed to rule as if we had said the thing that made the transcript short.
And brainstorm all the ways we can preserve this case.
You're supposed to brainstorm. If you're a lawyer, like thinking is in theory, part of the job description.
The judge says the case has a terminal flaw. And then the defense says, I agree. And the people say, we don't agree. And the judge says, yeah, it has a terminal flaw. It was not,
That's hilarious.
there was no discussion.
Yeah, but now you're agreeing that there was a flaw. That's the issue. You're not even disputing the fact that there was a flaw. So again, we're just at the remedy point here.
Really, on how to preserve the case. This, when we got to that point,
Yeah, there was no discussion because you didn't discuss it. You were there, not you personally. But like, you had a say.
it was, let's put on the record the reasons for the dismissal.
Okay.
It was clear from the outset. The court leading in talked about why it found that there was the due process issue.
Okay.
And then it gave both sides a brief opportunity to speak and found the due process issue. So, yeah, we're going to come up with a ton of stuff later because there was no time to come up with a ton of stuff then. This case is being dismissed. Do you have anything to say?
Yeah, but you had time to propose an adjournment. So clearly you had time to consider alternative remedies. And you also had time to withdraw the alternative remedy.
Counsel. Now, I understand that the court found that there were issues. Okay? And quite frankly, we wouldn't be here if it was any issue not rising to the point of a dismissal. If the court had imposed any sanctions or...
He's doing it again. He's conflating the two versions of dismissal when he's already been called out on. He's already been called out for conflating the two, and he's doing it again.
Requirements on the prosecutor to either what we are allowed to say, what we are allowed to do, when we are allowed to go forward, what we had to provide, any of that, and we wouldn't be here because we would have complied. And that was one thing that the court found. The court found that the people were trying to comply with everything.
Yeah, that's why it was without prejudice.
Why not just
Trying and not finding bad faith, finding that someone was actively doing something and finding that someone wasn't acting in bad faith or not doing something in bad faith isn't really the same thing. I think that's a leap there, unless I can see the actual filing and what he said is word for word what the court found.
Yeah.
then just refile the charges? Help me understand.
Yeah.
Going back to
again, if they had found prejudice, if they had found intentional wrongdoing, it would have been with prejudice. So I mean, nothing he said really rebuts the court's decision as far as I'm concerned. Aaron is a lawyer.
Square one. And it wastes judicial resources. It wastes the prosecutor's resources.
15 years.
It resets everything.
Yes.
And quite frankly,
she looks so confused. Like, yes, this wastes time, but you're just realizing that now?
Yeah, and also, like, sometimes you should, quote-unquote, waste time. Like, if there's stuff that's turned over the morning of trial, it's okay to waste a little time and start over. That's perfectly fine. That's a good reason to waste time. I wouldn't call it a waste, but yeah.
Just checking his watch.
It wastes the prosecutor's resources.
She does have a funny face.
It resets everything.
Yes.
And
yeah, that's not a bad thing, though. Sometimes you want to reset.
Quite frankly, we were at the point where trial should have been going shortly.
Yeah, and that's when you turn it over. That's the point.
But this appeal is certainly delaying that. I mean, if we're talking about, judicial resources, prosecution resources, and delaying trial, one could argue that this appeal has checked all three of those boxes.
Yes.
Okay.
Absolutely.
So I'm not sure that. So do you have anything other than those three boxes to suggest why simply, again, getting your discovery house in order and refiling the charges would not be a more than sufficient option for the people?
Seriously.
There's also the issue of witnesses and them retaining their memory after a longer.
Oh, stop it. That's never sufficient. This actually came up in Wolfenbarger, by the way. The state repeatedly argued that its passage of time isn't prejudicial merely because of lapses in memory over time.
Now,
different state.
Quite frankly, what you pointed out is that.
Also, I'm sure Kat's going to say it was 15 years ago. I don't think their memories are going to, or 25 years ago. I don't think their memories are going to erode because of another couple, 2 months, 3 months.
This appeal, all appeals take a while. And that is perfectly legitimate.
Don't appeal.
But
And just refile. That's the
we
point.
also have the duty at the prosecutor's office
You're
when
gonna
we
say something,
see
though.
that there is something that is being mishandled. And we believe that this was mishandled by the circuit court. Now, don't get me wrong. I do not want to suggest that the people have a problem with the circuit court, where the people feel that the circuit court was doing what it felt was right.
This is a long sentence.
Dismissal as
He's doing it again. He keeps saying dismissal instead of dismissal without prejudice, making him crazy.
a base level sanction, even dismissal without prejudice,
Oh, there you go.
is something that will, as a practice, cause intense problems
How? What problems?
throughout this.
Counselor, you have about 5 minutes of argument left. I don't know if you wanted to reserve anything for a rebuttal.
Yeah, I might as well do that unless there's any other questions that the panel
Might
has.
as well.
Look at the face in the gallery.
Oh, not for me.
Okay, thank you.
Thank you.
Awkward.
Cat could be a lawyer. So could I'm not a lawyer, but by the way, there are plenty of people who do legal coverage that are perfectly qualified. Yeah, I don't even understand where he's going with that. That should be fun. What's with the long hair? Bunch of hippies in Michigan. My goodness.
Good morning, judges. Blaze Kearney on behalf of JRobichaudEsq. Judge Swartz, I think
So maybe this guy's going to go for 20 minutes and this guy's going to go for 10. He probably doesn't need to say anything. Just get up there and be like, yeah, I appreciate you guys for dunking on the state. If you don't have any questions, I'm going to sit down now.
you hit the nail on the head when the decision of the trial court here fell within the range of principled outcomes, is that it wasn't the most extreme sanction or remedy that could be offered, the dismissal without prejudice. It wasn't an adjournment. It wasn't a particular curative instruction, one of which was withdrawn, the other which was considered and rejected. And so under the abuse of discretion standard here, the trial court should be affirmed because it wasn't an abuse of discretion
No,
for
definitely
the
not.
trial court to dismiss without prejudice the charge in this case.
Yeah, it's hard to imagine a scenario in which dismissal without prejudice is going to be abuse of discretion.
And that's true underneath the
Unless it's for no reason at all.
rubric of due process, 6.201, or a remedy for a Brady violation. A decade after Mr. Searcy and Mr. Ewing were imprisoned, and only after a new trial had been ordered, it was discovered that the prosecution had withheld a Mirandized confession of the man who was responsible for this murder.
That's bad. That's not ideal.
Mirandized confession. What does that mean, chat?
Tell us, Kat.
Well, who would be aware of something? Who would be aware of this confession or whatever was on the statement if it was Mirandized?
Is it the police?
It's not just something scribbled on a piece of paper that somebody says they found in a couch cushion.
Nope.
Wow, yeah. Yeah, the chat in unison goes, wow.
In the lead up to the retrial,
This is all in the context of due process discovery. It's not a discovery violation. It's fine. Look at the lady in the back.
defense counsel concerned that the prosecution had additional exculpatory information it had not disclosed. The defense undertook every effort.
I probably showed this in the Cat stream at the beginning more, but yeah, you're not going to get a lot of sympathy from the judges when the context is a retrial after 10 years of imprisonment because of withheld Mirandized information. If it's these guys did 10 years in prison when there was a confession by somebody else, and you're complaining about a dismissal without prejudice, I mean, come on. You're not going to have a lot of sympathy in that case.
Filed motion after motion to try to compel what Mr. Searcy was entitled to under our Constitution, the federal Constitution, and the court rules. And time and again, the prosecution claimed that it had disclosed everything that it was required to for 3 years. And that wasn't true.
So the prosecutor on appeal indicated that the real problem, or at least a real problem, is that the trial court looked at this, at least in part, through the lens of due process rather than just an ordinary discovery violation. It looks like an ordinary discovery violation. I don't know that I see the due process there. Is that something that is concerning for us on appeal, or can we treat this as a decision made with regard to discovery, whether you call it the due process or anything else, and look at it through that lens?
I think both would justify the outcome of affirming the trial court in this situation. As a matter
absolutely.
of course in trial court, because you're not citing 6.201 when you're engaging in discussions. Almost goes without saying, because we're talking about discovery violations. I think the nature of what happened here is the number and the intensity of the discovery violations accumulated into a due process violation. Because the requirements of 6.201, specifically subsection B, largely overlap with the prosecution's due process obligations, that I think the result is justified, whichever lens the court uses to actually look through it.
Is it also fair to say that it was the discussion with the original officer in charge, I think on the Friday before trial, that really kind of pushed this trial judge maybe over the edge a little bit? But as I recall, that discussion had more to do with Mr. Ewing and not your client. Does that matter? Do we have to look at this as, with each individual defendant, or because it was consolidated, do we just look at them as...
Oh man, this is funny. I'm gonna make sure you can see this. How do you withhold a video of a confession to prosecute someone else when you have a confession? If you weren't here at the beginning of the stream, I literally talked about a case where that's exactly the issue.
That's kind of a group.
A couple of things. This is a little bit of a multifaceted answer, so it's going to take me a second to get there. But it does relate to Mr. Searcy and Mr. Ewing, because the particular piece, and I think this is bigger than just those three pieces of evidence that were discussed sort of at the last minute. There is the Beal-Dotson recording, which is actually, I think, the most important piece of evidence. It's undeniably exculpatory. In this case, the government's theory was that Mr. Searcy and Mr. Ewing committed this murder. The defense theory was that Tyree Washington, the man who confessed under Miranda warnings, and William Beal were the people that committed this murder. This lost tape recorder, recording tapes, contained a statement from William Beal that he was there and describing the murder. So it was diametrically opposed to the government's theory. So that was lost, and what was left was an informal summary generated by, I assume, somebody at the prosecutor's office. It's without attribution, but has a sticky note on top of it that says Theo has the recorder and tapes. Now, Theo refers to the officer in charge. That's Theophilus Williams. And so,
good name.
Obviously, that would be exculpatory as it relates to Mr. Ewing and to Mr. Searcy. In addition,
what I like is he's like, this is going to be a complicated answer or a long answer, and then he actually answered the question instead of saying this is going to be a complicated answer and just rambling for 5 minutes.
While Mr. Ewing was requesting the interrogation videos of Theophilus Williams that he had engaged in, during which he says not only the gang affiliation stuff, denied affiliation in this gang, but also said that Theophilus Williams threatened him and made statements to the line of like, if you don't give up who did this, I'm going to make every effort to make sure you go down for it.
That's very common.
That was what was specifically requested. But what Theophilus Williams said in response to the prosecutor is, no, also Mr. Searcy was interrogated. I remember Mr. Searcy being interrogated as well. So Mr. Searcy's interrogation. And so in that way, the interrogation videos, I think the fact that the officer in charge allegedly on that video was making statements that could be amounted as engaging in bad faith conduct to make sure someone who didn't do the crime went down for it would also be admissible in Mr. Searcy's case, in addition to the lost interrogation video of Mr. Searcy specifically. Thank you. Yeah. I think it's important to that the court reject the prosecution's argument that the entirety of due process, that the full rubric of due process and how missing evidence issues are litigated or remedied by the court under due process is cabined exclusively to Brady and Youngblood. The United States Supreme Court nor the Michigan Supreme Court have ever held any such thing.
No, because that'd be crazy.
It is a flexible standard, and the trial court's core obligation is to ensure that any trial that happens has a degree of fundamental fairness. And so both the Michigan Supreme Court and the United States Supreme Court have described, the due process protections much more broadly than saying this is cabined to Brady and Youngblood. And you don't have to go further than the case of Youngblood itself to actually reach that conclusion, because in Youngblood itself situates itself in a broader scheme of due process. Justice Rehnquist says that Youngblood is what they call can be loosely called the constitutionally guaranteed access to evidence cases, which comes some from the compulsory process clause, some from the due process clause. And Youngblood is dealing with a very, very specific situation. There are two prerequisites before you get to the bad faith sort of conclusion that Youngblood is famous for. The first of those is that the prosecutors completely complied with Brady in that case. They disclosed everything they were required to disclose. They didn't hide the ball in any way. They didn't make any misrepresentations. The evidence was spoiled. It was biological evidence that couldn't be tested any longer because it hadn't been properly refrigerated.
Wow.
And so the prosecutors were open and honest about everything that happened in a timely manner. That's thing one. Thing two that's prerequisite in Youngblood is that the evidence was only potentially exculpatory. Because it was untested biological evidence, it was an evidentiary black box. No one had any indication whether or not the evidence that they would test would actually result in exonerating the defendant. And so the question the court confronted in Youngblood didn't have anything to do with prosecutorial misrepresentations and had to deal with potentially exculpatory evidence. And the question was the appellate court correct in upholding a dismissal with prejudice under those circumstances? They said no. They said you need evidence of police bad faith if under those circumstances you were going to consider dismissing this case forever. And so I think, you flip to Brady, which by its own terms in the actual text of Brady itself says that the Brady obligation exists irrespective of the good or bad faith of the prosecution. And so neither of these doctrines provide for situations where there are prosecutorial misrepresentations that lead to late or non-disclosed evidence that the defense cannot make use of at the time of the scheduled trial. And that's the situation here. And the idea that prosecutorial misrepresentations are not permitted in the presentation of evidence has existed long before Brady. Brady's a 1963 case. We cite in our brief at page 20, Pyle versus Kansas, Napu versus Illinois, Mooney versus Holohan, all of
Napui, that's one of those names that nobody can agree on. I still don't know how to say it.
Which related to the prosecution sort of mendaciously presenting evidence at a trial, and that's a violation of due process because of course it is. A trial court needs to be empowered in some way to remedy issues when the prosecution's misrepresentations have affected the substantial rights and the fundamental fairness of a trial. And so I think the necessary antecedent is if the prosecutor cannot make misrepresentations in the presentation of evidence, it also must be, at least under some circumstances, that the prosecutor cannot make misrepresentations as it relates to the disclosure of evidence that's necessary for the defendants to exercise their substantial rights. And so I think that in our brief, we talk about Valenzuela Bernal. That's a case that Youngblood cites that does this analysis that says, is what happened here, which is not a circumstance the court has seen before, rise to the level of a due process violation that infects the fundamental fairness of the trial.
Hey, counsel, does the constitutional versus non-constitutional characterization of this matter?
No.
Here?
I think it depends on what the court means by matters. If the outcome is the same that this court should affirm, I don't think it matters whether the court finds that the court's finding of general due process violation here was justified, or that under 6.201, the court's finding was justified. I mean, People v. Davey makes it very, very clear that among the rubric of options that the trial court has before it when considering a remedy for a discovery violation includes dismissal of the case.
Yeah, I'm gonna Sirach here says this argument is so much smoother. I was just thinking the same thing. Even though Sirach isn't here, I don't believe this is a really strong argument
without prejudice. And so, if the court means that,
I guess is the format of relief any more appropriate under one characterization than the other?
No.
I mean, I think that
it's fine either way.
I think the court said due process. I think the court meant due process. I think the transcript of that day, the court was faced with a dilemma, as I think you all had, your honors had indicated during Mr. Hebel's argument, that it had a real dilemma there. It could not have a trial that day that would comport with due process, not when there's still exculpatory evidence that's missing, that would impact the way the trial would go, especially as it relates to the recorder. the recorded statements of William Beale, that we don't have the actual words. We have an unattributed transcript that would be almost impossible to impeach somebody with. And so there wasn't a written adjournment request before him. It would be difficult to fashion a curative instruction, and Mr. Hebel suggests they could be prohibited from introducing gang evidence. I don't think that was the main thrust of what the issues were here. But also, the issues weren't confined to like whether or not the prosecution would be able to introduce inculpatory evidence, but rather whether or not Mr. Searcy and Mr. Ewing, who, let's be clear, were having witnesses driven from federal prison around the country. They're Wayne County Sheriff's deputies en route to go pick people up in Oklahoma when this happened, would be able to actually make use of that material that was lost or late disclosed in the course of the presentation of their defense.
I don't know. Good luck.
And so, yes, I think under People v. Davey, the court balancing all the interests that were before it landed on one that was, not unlike an adjournment when you think about it. Sure. The only side effect is that it doesn't punish Mr. Searcy and Mr. Ewing with continued incarceration.
Well, I mean, we've talked about the issue of timing with opposing counsel, and arguably pursuing this appeal rather than going and seeking to refile very, shortly thereafter, after the dismissal. Maybe that has used up more time. I don't know. Explain to me the process that you understand. Let's say that the prosecution took 60 days and just went back and scoured everything and satisfied themselves, and they believe could satisfy a judge that all the discovery had appropriately been found and could be turned over, and then refiled on day 61. How long would it take for
less time than
the trial to take place after those charges are filed, assuming we don't have a lot of the pretrial stuff that we've already gone through? A lot of the motions wouldn't have to be re-argued. How far along in the process would it have been if the prosecution had done that, taken that alternative route?
It would take less time than an appeal, almost certainly.
Yes, I get it, but give me your best guess.
I think that's going to be a function of like what the trial court's docket was looking like. So it's
Wayne County. It's the docket that is there right now.
Yeah, understanding that, I don't practice any longer in the Wayne County trial courts. I do know during this trial that the trial date was set in June of 2023, so it was set 9 months out. And that's the point they had sort of arrived at the final conference. All the motions have been filed, all things of that nature. And so,
so at least a year out from the from the refiling, at least a year.
Correct. Fair. But I don't think the result would have necessarily been all that different. The difference is that 60 days, right? So the trial court always is trying to prioritize the oldest cases, the ones that are where people are incarcerated, to go first. And so you're always getting to the end of the line.
If they had to adjourn, presumably it would have been just as difficult to come up with a trial date.
Yeah, you would have had to reset.
Because, in terms of just getting the jury and everything, if there was an adjournment, would they have realistically been able to have a trial within 60 days, or would it literally have been in a year?
I think it's more likely, obviously this is a hypothetical, I think it would have been closer to the year. And the reason is that the prosecution endorsed more than 30 witnesses at this trial. The court had set aside 3 weeks. The defense had 50 witnesses on its witness list. Obviously, it probably wasn't going to call 50 witnesses, but had written people out from federal prison. The Bureau of Prisons requires a significant runway because it has to physically hand off federal prisoners to the custody of Wayne County Sheriff's deputies, who then have to drive them across the country. And so, getting through the federal red tape to get somebody out of federal prison to testify for the defense can be a significant undertaking.
Well, adjournment would not just have been a delay of a few weeks. It probably would have been a very substantial delay. Is that fair?
I have every reason to suspect that would have been the case. And so I think that it's important to understand that, the trial courts afforded an abuse of discretion standard for discovery violations and these due process determinations, because trial courts are expert and the bulk of their work is facilitating the exchange of information. Almost every single hearing that the court can see from the record in this case was one at which discovery was disclosed and discussed, or not disclosed and argued about, all the way from 2021. There are motions to compel being filed into 2023, and then obviously what happened in 2024. And so, I disagree with Mr. Heeple that this is a very short transcript. The trial court makes very clear in the course of that transcript on page 5, 7, and 12.
He's so prepared.
References
At least
to
12 pages.
this is just the main issues we've been talking about just this past week, is how he discusses it. Once it becomes clear that the prosecution has backtracked on a lot of their previous representations, he sort of wonders aloud. He's like, well, what does this mean for everything else? In reference to, at that point, this particular trial judge had been litigating these issues for 9 months. He had been requiring the prosecution to file a 24-point status report on what their progress was in discovery that was being updated frequently. And, had been dealing with upwards of, I think, 40 of pretrial motions that had been filed by Mr. Ewing, many of which had to do with discovery. And so I think this was not limited to what happened on March 25th of 2024. It had been ongoing for a long time. And I think all the way back to the initial motion to compel that was filed in November of 2021 about these issues. Another thing I'll disagree with about Mr. Heeple, that Mr. Heeple said, is that this was a case where these brand new prosecutors were dumped into it. They had no idea what was going on.
Doesn't matter.
They weren't able, they didn't know what they didn't know functionally. The original trial prosecutor handled this case for the majority of the time that this spent the 3 years leading up to the retrial. So the original trial prosecutor came back for the case and handled it from March of 2021 through sometime in 2023, at which point there was an intermediary prosecutor. And then these prosecutors that sort of were there for the last 9 months came in June, sometime around June of 2023. And so, a lot of the litigation, a lot of the representations that the government's disclosures were complete. They had turned over everything twice. At one point, the trial prosecutor staked her reputation as being a prosecutor in that courthouse for 30 years to vouch for sort of the completeness of her disclosures. And a lot of the discovery litigation had been by the original trial prosecutor. So I think that while the prosecutors were standing in front of the trial judge, had only been on the case for 9 months, and I say only 9 months because the court was clearly very frustrated because they had repeated a lot of those same representations. I think that that also explains that why the trial judge had these comments where he says, well, these prosecutors have, I think said been diligent in trying to run some of these issues to the ground now, albeit in the last couple of weeks, but they had actually made efforts and had actually, said, hey, we got it wrong. Previously, there might be more. So I think that was the trial judge recognizing that these were sort of the folks that actually finally got to the bottom of it. And it wasn't excusing everything that had came before. So I think that the prosecutor's years-long assertions of compliance with discovery obligations only to backtrack at that last moment really caused the loss of Mr. Searcy and Mr. Ewing's ability to make use of the exculpatory value of a lot of the evidence. I mean, one of the identifying witnesses died in this case.
Was it
others
the
couldn't be
identifying?
impeached, as I discussed, as a result of what had happened. And an additional witness the other identifying witness didn't show for trial. That's also in the March 25th transcript.
Oh.
And so Mr. Searcy and Mr. Ewing were faced with the prospect of having a trial with new exculpatory evidence that they couldn't make use of, where they were never going to be able to cross-examine the identifying eyewitnesses based on the new information that had been disclosed. I think that means that the trial judge correctly found that they could not have a trial that day that would report with due process.
Yep.
And if the government feels that they could gather all this information, they're welcome to do that. They could have done that during the pendency of the appeal and refiled the charges. So I think that the government has not been harmed in any way by what the trial court did, that it didn't reward the government by giving them a windfall of adjourning the case and leading to Mr. Searcy and Mr. Ewing's continued incarceration. So I'd ask the court to affirm because this is not an abuse of discretion.
So it's your belief that they could refile during the pendency of this appeal?
I would say I'm not a huge expert on whether or not that would be proper.
I don't think it would be.
I certainly think that we may have something to say about that if it was done at the trial level. But I think I would say at minimum, other than electing to pursue this appeal, they could have just simply refiled the case.
Okay.
Oh, that part.
Okay, thank you.
Look at his face here in the gallery when he says this.
Yeah, he's a very expressive face.
Any other questions?
He's like, yeah.
Okay, thank you.
Yeah, I don't think he was suggesting that he could refile during the appeal either. I think he was saying they could gather the evidence during the appeal and then refile on affirmance. Anyway.
Good morning, and may it please the court. I am Raven Lockridge, a law student with the Michigan State Public Defender Clinic, arguing under Michigan Court Rule 8.120. I'm here on behalf of Mr. Ewing, who is joining us in the courtroom today. This case has been ongoing for 15 years without a resolution, and through it all, Mr. Ewing has maintained his innocence.
She's doing pretty good.
March of 2024, Mr. Ewing finally gets a chance at a fair trial, where Mr. Ewing filed over 40 motions, including motions for evidence to receive evidence that he previously did not get. But yet he was still met with months and months and months of lack of preparation and diligence by the prosecution. The Friday
Oh man, imagine taking an L to a law student. That's embarrassing.
day before trial at 12 p.m., as you stated, Your Honor, the prosecutor decided that they want an adjournment. But at the start of trial, decided we should actually continue trial and just limit the jury instructions. The court explained that they could have not continued trial this way. It wouldn't have been fair for Mr. Ewing. So
If we look at this as, I don't want to say ordinary discovery violation, but the kind of discovery violations that happen in criminal cases, if we look at it through that lens, is it still appropriate for the trial judge to have dismissed?
He is asking, these are softball questions. He asked the same question to the prior appellate attorney. I think he's very clearly taking the position that irrespective of whether it's a discovery violation or due process more generally, the remedy would be appropriate in either case, and that the state's attempt to distinguish due process from discovery is a distinction without a difference. This question is very clearly a pro-defendant question.
Rather than some lesser option, an adjournment, a jury instruction, a foreclosure of bringing up certain topics.
yes, Your Honor, it was appropriate. It would have been appropriate for the judge to dismiss without prejudice under these circumstances.
So why?
Mr. Ewing had been filing motions. He was also in jail at the time that this was going on. The prosecution knew that the judges trusted the prosecutor to get the evidence.
Move it
The
along.
prosecutor knew that they needed to get the evidence. They continued to explain that they did not have the evidence, but yet would come back with evidence that they found in the back of the box or wherever they had it. And
I would have hit the air quotes there. They found.
during that time, Mr. Ewing was in jail, and the appropriate remedy, balancing the light of the circumstances, was a dismissal without prejudice. And adjournment, which they took off the table, as you stated also in your first questioning to
Run
the
it back.
prosecution.
I like
They took
her.
an adjournment off the table, and they wanted to continue trial. So he considered the adjournment, he considered the limited instructions that they asked for, and found that those circumstances would have not been proper in this case to continue. So dismissal without prejudice was proper.
I agree completely.
And we can see this happen in the case People v. Evans that this court decided December of 2025, where it's an unpublished opinion. We couldn't file a supplemental authority because it's unpublished. So the court number is 371196. And in that case, the trial court dismissed the case without prejudice due to the prosecution not having witnesses show up on time after the judge gave them multiple time to find the witnesses and get evidence to bring to the court. And the last time that they told the judge that the witness they were looking for was actually deer hunting. And so they couldn't bring the judge dismissed without prejudice. And this court
Well, it was an
affirmed the very
emergency.
exact thing. The same thing happened.
Counsel, I'm sorry to interrupt,
No,
but
you're
what was that? What was the nature of the error there? Was it a due process violation? Was it a discovery violation? Just tell me a little bit more about the case.
The court didn't explain that it dismissed based on due process or discovery. It dismissed, but the nature of the conversation was about discovery and having a witness on time and having the evidence discovered in the case. So just like here where the judge never explained, this is a blanket discovery violation. It's clear that the conversation was around witnesses and evidence and discovery, and the fact that the evidence and the witnesses were not available and they did not act diligently to make sure that the evidence and the witnesses were there, they couldn't continue trial. And that was then the trial court's discretion this court held.
Yep, absolutely.
Further,
That gets
the
back
court
to the first
properly
judge's, the long
exercised
hair judge's question.
discretion when it dismissed without prejudice based on 15 years of remedy, as Mr. Blaze pointed out, counsel for Mr. Cersei pointed out, that it would have been proper because of the exculpatory evidence that Mr. Ewing was deprived. We adopt Mr. Searcy's arguments in full, and I'll be happy to answer any questions. If not, I'll move further.
So this will be a good criminal procedure question for an exam someday. Do you
Oh,
know whether
They love her. They love
prosecution
having
could
this
have
happen.
refiled
They do.
charges against the defendants during the pendency of this appeal?
I don't think they could have.
From my limited knowledge as a law student, I believe that they could have filed charges during the pendency of this trial. They could have actually, instead of filing the appeal and taking time right in the brief, they could have probably just refiled charges.
But I mean,
He knows
that the
that.
prosecutor had the right to bring this appeal.
Yes.
And so let's just assume that's
I
what
can't
happened.
imagine they could have
Do
actually
you
filed
know
during.
whether, while this appeal is going on, a separate set of charges against the defendants could be brought?
A separate
It'd
set,
be
yes.
two new cases, but it would be it'd be the same, set of facts and circumstances here. Do you know whether during the pendency of this appeal, those charges could have been rebrought in a separate case, and then we have basically parallel proceedings going on?
I don't know about parallel, but they could just dismiss the appeal and refile.
Given the fact that they couldn't continue trial with what they had, they could probably have started trial if they got their ducks in a row and refiled charges and also did the appeal. But I'm
That's
not
funny.
sure on that. But I think that would have been right because the judge dismissed without prejudice.
Yeah, I have no idea the answer to
Further,
that question.
this court also should examine a balancing approach that would call for dismissal without prejudice under the Michigan Due Process Clause. Arizona v. Youngblood, as counsel before me has pointed out, that a denial with due process is only available if the defendant can show bad faith based on the prosecutor or the police actions or potentially exculpatory evidence. The dissent in Youngblood pointed out that defendants will receive unfair trials throughout this country because of Youngblood. And as legal scholars have pointed out that only 7 out of 1,675 defendants have ever been able to meet that burden for the federal standard. And the criticism is not alone. Delaware has used a certain balancing test under its constitution, and 10 other states have joined to provide greater protections other than Youngblood. We ask this court to examine whether or not for the first time this is appropriate, as I know that this court cannot overrule Youngblood. That is a question that
You don't have
is
to overrule
already
Youngblood.
codified because the Supreme Court has decided that. But Mr. Ewing asked this court to
They can give
examine for
additional
the first
protections,
time
not
whether
covered
or
in
not
Youngblood.
under our due process clause, Youngblood is not the proper standard. And for all those,
Would it be appropriate for us to reach the constitutional issue if we can decide this on the discovery issue?
if you could, this is an alternative argument.
Yeah, they're not going to do that. I think they've already made up their mind. They're just going to affirm. That's not abuse of discretion.
Our prior argument is that this case is the trial court was
They're
within its
never gonna do
discretion
that.
to
It's a good
dismiss under
argument, though.
Michigan Court Rule 6.201, in that it was proper to
I admire
dismiss
the
without
ask, for
prejudice.
sure.
If the court reaches the Youngblood question
They
and
won't.
decide that the discovery question is not in no way, shape, or form the way to go, it should look to the Youngblood alternative under our due process clause as an alternative. If not, I don't think that it needs to be reached if the discovery violation question is the answer.
Oh, this
Because
looks
we can
very
avoid it
good.
under the constitutional avoidance doctrine. Is that,
Yes.
that's the conclusion? All right.
And for all those reasons above, this court shall affirm the trial court
Yeah, she's
decision,
doing great.
dismiss the case, and that dismiss the case without
Look at him.
prejudice. And if the court disagrees, it should remand for further consideration under the proper legal standards. Thank you.
Any questions?
No.
Okay, thank you
Yeah,
very much.
they love
Thank
her.
you.
They loved her.
Counsel rebuttal?
Yes.
Bro. I know you got a job to do. I know you've probably been working on this one for a while. This ain't it, Chief. I am curious to see what he made a face when the first appellant or appellee attorney said that the original trial prosecutor was involved with the retrial. I'm curious to see if he's going to attack that statement. Other than that, I don't really care what
He's
he
like,
says.
I'll have you know my
Thank
ducks
you,
are in
Honors.
a row.
This court has jurisdiction. And therefore, we can't refile.
Yeah, I think he's right about that, by the way.
Once this court takes jurisdiction.
He's answering the law. He's using his rebuttal to respond to the law school question. He's like, see, I know more than her. Oh, man.
All matters below would be stayed in.
He's still not answering the question completely, but I think he's right.
In the expectation that this court will dispose of this case in some manner. And after that, then there's another 56 days for either party to request leave to appeal to the Michigan Supreme Court.
So maybe it's a technical point, but do you know if charges had been refiled, let's say, again, my mythological 60 days were taken and charges were refiled by the prosecution after those 60 days, would the two cases that were dismissed be reopened and restarted, or would these be two brand new cases?
Brand new
They would be
cases.
brand new, and
Okay.
they would be set on the same track to.
So assuming that, it's your belief that two new cases could not proceed along a parallel path to this appeal, even though, and the practical effect,
Yeah, I agree. Aaron says, I also think he's right. I just don't think that's what he's spending his 5 minutes for rebuttal time on. Yeah. It's just, I think the judge is just interested, like hypothetically, but I don't think it has anything to do with the disposition of the appeal. I mean, I'm pretty sure he's right, though. I can't imagine you can file a new case while you have a pending appeal on an open case in the same facts. I'm interested, though.
Rationale may not make much sense to keep them parallel, but it's your understanding that because the same facts and circumstances would be involved, even those completely different cases, those would be stayed or somehow paused while this appeal took place.
It would be my understanding that they would have to be, because
It's like a double jeopardy thing,
we're
maybe?
appealing a ruling where the judge dismissed without prejudice as errant, which means that this case survives. And while this case survives in the Court of Appeals until you decide what to do with it, if we charge again under the same facts and circumstances, and that's double charging, we are in violation of double jeopardy.
Hey, there we go. I agree with him on something. Well, he agrees with me.
I'm not sure it's double jeopardy, but I think you're right. I mean,
I'm not sure
it
either.
seems odd, and maybe I don't need to waste time going down this. It's just an interesting criminal procedure question.
Absolutely.
What would be the practical timing difference between whether an adjournment had been, like a 60-day adjournment had been granted versus the prosecution refiling after 60 days?
An adjournment would get dealt with much, much faster, because once
Why?
again,
Because this trial
Mhm.
sounds like it was going to be a logistical nightmare, and it was going to probably be at least a year and a half out from the adjournment, or not.
I would think it would be within the next few months, because when you have an adjournment, the trial courts all try to shift things to get that case on, because that is an ongoing case that's on their
That's
docket.
fair.
When you have
be right about
a
that.
brand new case coming from zero, okay, it gets put at the back of the line. All right, it gets put at the back of the line at every single stage.
He's probably right about this, too.
Okay,
Not that it
so
matters.
we would be talking a significant delay in starting from scratch. So the defense has requested that this court create a new due process rule. And I believe, as
I don't know if that's true.
counsel for Cersei put it, they wanted to create a new rule about the prosecutor being wrong about evidence, and saying, "Hey, we've turned over everything we have," and then they find evidence and they turn that over.
They didn't really
Boom,
find
due
it. They already had
process
it.
violation because prosecutor was wrong about evidence.
Okay.
Yeah, I would have done dozens of due process violations, not intentionally, just because I am not all knowing. And people come to me, "Oh, hey,
That's a wild thing to say, first of all. Okay. I wouldn't have admitted that.
Did you see this? No, I didn't see that. I've never seen that before in my life.
Also, he's completely missing the point. It's not as if there was new evidence that was discovered for the first time. It was evidence that was already in the state's possession. So it's not really... This is all. I don't think any of this is relevant to the disposition, but...
First thing I do, I pick up the phone call defense counsel. Under that rule, I'm now in violation of due process.
Well, I guess
Yeah, that seems fine with me.
this isn't it more, I guess, in that framework, isn't it more about sort of just the situation and how it lands? I mean, if that happens, weeks or months before trial, then maybe it's not the same that it happens the eve of. And that's sort of where you get into the fundamental fairness.
Well,
Yeah, exactly.
when it's due process, it's either one. If you're arguing that, we're talking discovery violation, prosecutor said I had everything, now he says he doesn't.
It had everything for years.
Okay, that's one thing. But if we're talking like, cheating somebody out of fundamental fairness by calling them late and saying, "Oh, hey, I have something new," that's not a due process violation.
Yes, I'm struggling with if we don't get hung up on the label, because certainly a discovery violation can amount to a due
We're back to
process violation.
struggling.
But if we just say there were some discovery problems here, what is your argument that there was an abuse of discretion when the trial judge picked dismissal without prejudice rather than a lesser option? If we're just looking at this through the lens of discovery.
All right. And that's the crux of this, is whether or not we have the right
After all
result
this
with the
time.
wrong ruling, which, as this court knows, can be affirmed. I know that's not helping my case right now, but
Credit for admitting that.
that's the question. If we look at this as a
Yes,
purely
that's why he asked
discovery
the
issue,
question.
I want to read from
What are we
the
doing
discovery
here?
statute, just very briefly. And that is 6.2.
Okay, I know there's this case. Somebody mentioned, Aaron says, still no update on Ed Hawley, back for day 13 of deliberations. What do you all do in the jury room when you're on day 13 of deliberations anyway? I mean, you can just I don't, how is that not a hung jury? What are you still discussing? You can fight it out. You can do like an entire bracket and just have some kind of fight to the supremacy at that point. That's crazy.
01
Exactly,
J concerning violations says that if the party fails to comply with this rule, the court in its discretion may order the party to provide discovery or permit the inspection of materials not previously disclosed, grant a continuance, prohibit the party from introducing in evidence the material not disclosed, or enter any other such order as it deems is just under the circumstances.
Any other such order
So-
as it deems just.
We have a full panoply of ways that the court can address it.
Including
The court-
dismissal.
The court
Yes.
could have addressed it in a dozen different ways.
And it did.
The court could have
In
said,
one of those dozen ways.
continuance, yes, there's a continuance, you go back, you find it, you show it to them, you show it to the court, you prove that you complied. No, this is nothing about the prosecutor getting an adjournment, this is a prosecutor doing it right, going.
Yeah, that was one of the options. And there were other options. And it was in its discretion which option to choose.
Do it.
So I presume the argument is, well, by dismissing without prejudice, that's the second highest, because dismissing with prejudice,
Yes.
but dismiss without prejudice. How did that prejudice the prosecution in comparison to how the prosecution would have been in prejudice under a lesser option, for example, adjournment?
An adjournment would have been dealt with much shorter, everything would have been dealt with much quicker, and this case would be going.
So it's really the timing issue.
The timing issue
That's
is
pretty weak.
huge. And the timing issue is a very serious issue.
Is it?
Counsel, you have about a minute left if you want to have any closing remarks.
Oh,
I like her. She's very
thank
nice.
you very much. In this particular case, the big flaw that the people see in this was that the other options were not considered.
They were. They
Because
were.
the trial court jumped right to due process
Yeah, this
and
is
from
the
there to
state.
dismissal. Okay?
They explicitly
The
were.
other options should have been considered. And the other options would have done better for both the defendants and for the people. Thank you very much.
Okay, thank you very much. Thank you both counsel. That case will be submitted. We are going to take a short 10-minute recess before we continue with the rest of our docket. Thank you very much.
Yeah, I mean, I don't see it. I mean, he keeps saying that the judge didn't consider anything else, but he considered at least two other things. Well, I mean, not the continuance, or whatever word they use, the stay, because the state withdrew it, but then he also considered jury instruction, found that inadequate. Dismissal without prejudice, I mean, it's not the end of the world, you just refile. Adjournment, that's right. Or adjournment, as the caption says. They should make these ruling quicker because I'm impatient. Yeah, they should just decide on the spot. They probably could decide on the spot. Okay. It's getting late here. I think I'm going to call it night because I got to do... Well, I have to do some work, but then I got to do... We're going to do the oral argument tomorrow morning at 10 Eastern, 7 for me. I'll probably be very, very awake and very happy. But we're going to watch the Brian Steele stuff. I feel like sometimes they wanted to decide on the spot. Yeah, definitely. I think the long-haired judge definitely signaled what the decision is going to be. They're not going to reach any of this stuff. They're just going to say it doesn't matter whether it's due process or discovery. We don't have to get into that. Either way, dismissal without prejudice is clearly within the range of acceptable options for a trial court judge. That's squarely within their discretion. Certainly it's on the high end of remedies, but it's not the highest. If the only prejudice is you have to wait a year instead of 6 months, that's not, I mean, that's really nothing. There's no statute of limitations issue that they're going to run afoul of. Not a big deal. And I do think that the judge was annoyed that they appealed rather than just refiling. And reasonably so. Aaron says, at that point, they've already reviewed the briefs. Oral arguments are basically just to elaborate on arguments that weren't as clear as they could be in the brief. Arguments and issues should be clear. Yeah, I completely agree. I think that's usually the case. I think it's pretty rare for oral argument to flip a judge's court's decision, at least in appeals. I think this is a case that could be pretty simple. That's just being overly complicated. But yeah, tomorrow at 10 Eastern, we'll do the Hannah Payne oral argument. There's a second case that is also, there's a second criminal case. I'm also going to watch that one. It's like a stalking case, I think. Hold on, let me pull it up. I'll show you guys the case announcements. Where are we? Here we are. There we go. These are the cases. Hannah Payne's the first one up, being argued by Andrew and Brian. Then the next one is Walker versus State. Again, this tomorrow morning. Byron Walker is appealing a decision by the Court of Appeals of Georgia that reversed a trial court's grant of his post-trial motion to invalidate. Oh, that's right. I remember. I think I saw this, the Court of Appeal. I remember this case. to invalidate his conviction for stalking. Walker has been convicted of aggravated stalking and violating a family violence order in Gwinnett County. However, the trial court granted Walker's subsequent motion in arrest of judgment, which challenged the aggravated stalking count. This is one of two ways you can attack a conviction after conviction. Either you can do a general demurrer. If there's a flaw in the indictment, I mean, you can do a motion in arrest of judgment or a general demurrer, which challenged the aggravated stalking count. The trial court found that the aggravated stalking count was substantively defective because it failed to allege all essential elements of the crime. Specifically, the count did not contain the language other than the residence of the defendant. Point being that if you're inside your own house, I believe you can't be stalking somebody. You have to actually leave your house and stalk somebody. Court of Appeals, the State Intermediate Appellate Court, reversed the trial court's decision, concluding that the aggravated stalking charge against Walker sufficiently stated the offense in the terms and language of the statute, sufficiently informed Walker Aaron, you got me again. Sufficiently informed Walker of the charge so that he could present his defense without being surprised by the evidence and protected him against another prosecution for the same offense, as he could not admit the facts alleged and still be innocent of the crime charged. Supreme Court granted Walker's petition, indicating that it was particularly concerned with the following issue: is an indictment alleging the crime of aggravated stalking fatally defective if it fails to allege that the place or places where the defendant is alleged to have stalked victims is not the residence of the defendant. Ooh, I forgot. We're definitely going to watch this last one too. This is a complicated one. It's also funny because Peterson, Hawkins, and Pinson are recused from the case. So it's going to be a 6-justice case, which is unusual. But yeah, that's what we're doing tomorrow. So I'll see some of you then. I know Afro Man is going to be on tomorrow, so maybe I'll switch over and watch some of that afterwards. Won't take any personal offense whatsoever if you guys decide to watch that instead. I know Kat's covering it, some other people. But yeah, check it out if you want to. And I'll see you guys tomorrow. Have a good one.